respond. They have already responded. Unfortunately, notice has not gone to the private opposite parties since it arises of the matter where the challenge was in the writ application to an ex-party order of the single judge manner. We had filed a review. And since review, my lord, I am duty bound to serve them notice, a right has accrued to them. I have also served notice to them by special measure, by.
No, but you are seeking review of the same order which is under challenge in the writ appeal.
No, my lord. This is a case where, my lord, a policy decision of the government, which is in a code, the code, my lord, is done away with without notice to the affected parties. My lord, I already asked the state to respond. State is supporting us, but the private opposite parties who had come in the writ, my lord, they have to be noticed.
Let the matter called. Let the matter be called.
May not reach, my lord. I'm only saying I have already served notice. If it comes up somewhere at 2 o'clock next time, whichever date,
it will come.
I think private parties are appearing. I think so. Check the cause list, please. That Christian regarding minority institution. Christian minority institution, that case.
No, 23 one.
Or 23, sorry.
Although I served notice because the right had accrued to them, I instructed the briefing council to serve them notice. It's affecting a whole lot of people, my lord, who are getting no work.
Is it that contract
Yes.
thing?
Contract.
That we had deliberately not issued to the private parties, saying that we'll see their counter. I think,
Yes.
if I remember. Yes.
They have already filed the counter
So we'll see the
supporting
counter.
us. And I have also served notice on the other side. My lord, I call it any date, my lord, at 2 o'clock or whatever date. suitable to my lord.
We may take up the matter today or Monday.
Deeply.
I beg your pardon to mention your lordship. One fresh tender matter, madam. Urgency
Give
for-
your slips.
Pardon to mention, your lordship.
Please give your slips.
Item number 20, your lordship.
First of all, out of list. Mr. Samarth, please give us.
Item 16 not fresh.
I have tomorrow the OPSC matter has been fixed at the first place. Due to bereavement of my family members, I have to attend this week. Tomorrow I will be absent. I have intimated to the other side. Can it be next Thursday? I have.
All right.
Somebody has to make a mention.
Make a mention tomorrow. We will recommend it.
With my lord's kind leave, Millets, item 19, we're all here. It seems, Millets, my lords are sitting single in the afternoon. That's the tender matter, Millets. My lords have said that it could be taken up at 2 o'clock.
So if it
It's
is not taken up
unlikely.
in the first half, we will take up because all of you have come from outside.
Yes,
We
Millets.
will take up after at 2 p.m.
At 2 p.m.
as special case.
So be it, Millets. Great.
Item
Pardon
16.
to mention, your lordship, item number 20. Kata Christian Education Board, your lordship. Kata Christian Education Board.
That is the one, yes.
Your lordship, need some time to prepare a note, your lordship. It's a bulky matter.
What do you want?
You should say an adjournment for a week, your lordship.
All right.
Your lordship, read appeal 2381 of 2020.
Give your slip.
I have filed the memo. Memo already filed.
All right.
Maybe taken next week. Your lordship. Maybe taken on next week.
You know, I see your slip and then. Mr. Seshadri, Mr. Naidu.
Yes,
If it is not taken up before this thing, recess,
yes.
then we will take up at 2 p.m. So if it is, please wait. If the,
Please, we are here.
No, rather, a request should be taken up at 2 itself because the board was earlier indicated to be at 2 o'clock. Till lunch session, I may have to adjust with other work on through virtual. That is it.
As my lord.
then it's difficult. Let us see what happens.
Yes, by 2 will be here. Please.
Item 16 not fresh. Item 16
All right.
not fresh.
That law.
In 22 minutes, that matter yesterday, three of us had mentioned. That tender matter, where we are challenging, the petitioner is challenging the cancellation and for steel of it. The tender, awarding of tender has been stayed. So, three of us had made a joint mention if your lordship can, I'm sorry, there's a lot of pressure right now on this.
Can we take up the matter tomorrow? Huh?
All three have consented that it can be taken up. All the contesting parties have agreed. Whatever time your lordship gives is agreed.
Your item is 22.
At 22 for admission.
19. All right, we will see.
Otherwise, tomorrow for orders, if I can make that request.
Why for orders?
There's an application for vacation of
Oh,
stay.
that we will take up.
My lord.
That we will take up on priority basis. Orders.
Tomorrow for orders.
Tomorrow orders, yes.
Grateful to you.
In this case, I am appealing for opposite party. Number 4. My Wakalatnama may be accepted.
Here,
I'll file in.
There is an office.
My lord, I'll file in.
Do it.
Great. Because our name not reflected. in-
All right.
how will it be reflected if you don't file the wakalatnama?
My lord, may I mention for the memo? There's an urgency in this case, my lord. WI case number 2.
That I will see. Orders.
Matter for orders. Item number 9. This is for withdrawal.
Withdrawn.
Yes. Item number 10.
Write the prayer and then.
Item number 10.
There is a delay of 62 days.
Notice. Notices have been issued.
Not yet.
Is it connected to any matter?
That if your lordship remember that Kamalini Vepari case.
That offline and all.
Offline and online.
So any specific date the other matter is posted?
By one matter, you're basing on the application subsequently made by the petitioner. Your lordship have already dismissed the writ appeal so far as that petitioner is concerned, disposed of. It is not dismissed but disposed of because government furnished the instruction that they are going to consider his application for upgradation because of. So this matter is little bit different because here whether
This we can also dismiss? No.
here I'll have to find out whether he has made an application pursuant to the subsequent notification made by the court, made by the authority.
That I think is an additional factor. Otherwise also, since you have granted, I think group A.
Yes, these are all group A service.
Since you have granted group B, I think the earlier division bench decisions are.
Yes, in Kamalini Vepari case, your lordship.
In that case where you said government has allowed, I think they've issued a letter saying as a one-time chance we are allowing.
Yes, to that particular person because.
Are you sure it is particular person or 2 persons?
No, my lord, because of the relaxation granted by the government
Yes.
for making online application subsequently.
Exactly.
He made an application and on instruction I produced a letter that he has already made an application and government has decided to consider his case. So here if he has subsequently made an application, I'll just take instruction. And so far as delay is concerned, your lordship may issue notice. So
Why don't you get the instruction?
I'll get the instructions. That would
Get instructions.
my lord. I'll get.
1 week as requested on behalf of the applicant.
Item 11.
Yes.
11, someone has appeared, last again also was absent.
Mahapatra is also there. Her name appears.
What is the delay?
415 days delay. madam. Earlier, Jyotiranjan Kar was appearing. I have contacted him along. Lordship has instructed me to contact him. Subsequently, that
Oh, notice. You are
has
not
been-
able to serve notice, but you contacted him.
no, my lord.
Then?
On last occasion, your lordship has directed me to take instruction regarding that Jyotiranjan Kar. Why he has not appeared on last occasion? I have contacted Jyotirandan Kar. He said that power has been transferred to Saraswati Mahapatra.
Bhagavatam is there. So Saraswati Mahapatra.
I'm just checking.
Yes, Bhagavatam is there. All right, no one appears on behalf of the respondent. Does this matter on 1 week?
Item 12.
Yes.
Yes, madam.
My lord, sorry, my lord. I am appearing in item 11. There is 15 days delay, and they have not explained the delay. My lord, there is a judgment of the Supreme Court where it says on 333 delay is not also condemned. That is not understandable. Why in 15 days delay they have filed? I will file my objection to the delay.
File it. Ms. Saraswati Mahapatra seeks adjournment to file objection to the application seeking condonation of delay. As requested, this is matter on 1 week.
My lord.
When? 1 week?
Next week, my lord. After vacation. It will.
1 week and after vacation?
No, 1 week.
Dispense with. Dispense with.
Item number 12.
So there are two IA minors. One is for bring exemption of filing of
What is the
exemption
delay?
certified copy. But I in the meantime, I have got certified copy.
What is the delay?
Delay, my lords, for me, my lords, there is no delay because I got the information of passing of the order only, my lords, on 15th, 4th, 24th. I have filed on 18 May, my lords, 8 May. Within a month, my lords, for me, my lords, because I was not employed as a party in the case.
Okay. Yes.
My lord.
So file requisites within 1 week, you file.
Requisite. Notice in the delay.
Delay because you have explained it, it will be allowed, but after hearing the other side.
In the other IA, I am filing the certified copy, my lords, in the meantime.
When will you file?
Today, my lords, I will file.
Dispose of as infructuous since you are filing today.
So, the limitation notice has been issued, my lords. Only thing in I have here mentioned, my lords, contempt is pending against it. And that is listed for tomorrow, day after tomorrow.
All right. That will not do.
Item number 13.
Oblige. They have 116 days. Friend has entered appearance.
The copy we served and the writ application.
Yeah. We have entered appearance.
Let I entered appearance.
We are condoning it. 116 days for state of Odisha is as good as within.
Let 2015. This case is 2015's recruitment. Am I
still
2015? Yes.
We have to consider the merits of the case.
Yeah, my lord. Yes. So limitation is 100 after filing contempt, they have filed this writ appeal. In spite of the lord's direction, specific directions, that is the place. So
5,000. 5,000 cost. All right.
Subject to payment of cost.
Yes.
But should fix a date so matter can have.
It will come. Make a mention.
How many days? 2 weeks?
2 weeks.
Payment.
Item number 14.
And for the appellant, my lord.
Yes.
Your lordship, this matter is about the fireman height It is there for judgment today, passing of orders.
Oh, it has come for orders.
Yes, yes, ma'am.
All right, we will tomorrow. That police.
Fireman.
Huh?
Fireman.
Fireman, yes. Tomorrow.
Item number 15.
Delay of 9 days in filing the appeal.
Who is on the other side?
This is coming for the first time. This is an ex parte order.
About. Delay of 9 days. Loss. 9 days delay control. 9 days. This for fresh submission.
Specially urgent matters, item number 1.
Last time your lordship asked me whether there is any state support agreement in between the central government and the state government. So I have got a copy of that state support agreement. It is in between the Ministry of Road Transport.
No, the main question is
Yes.
whether it is a reserve forest or not. If that is a reserve forest,
then the question
then there is
doesn't
no
arise.
question of any agreement or anything.
That's right. That's right. Lord, let me first place the Forest Act. There is a procedure where how a reserve forest is to be made. Your lordship sees it is almost the same so far as the Odisha Forest Act and the Indian Forest Act is concerned. Now I am taking your lordship to section 3 of the Indian Forest Act. Can you may I draw your lordship's kind attention? My Lord Justice Doctor. May I place my Lord section 3? The state government may constitute any forest land or wasteland which is the property of the government or over which the government has proprietary rights or to the whole or any part of the forest produce of which the government is entitled reserve forest in the manner hereinafter provided. Then my Lord, notification, section 4 is notification by the state government. Whenever it has been decided to constitute any land a reserve forest, the state government shall issue a notification in the official gazette declaring that it has been decided to constitute such land as a reserve forest, specifying as nearly as possible the situation and limits of such land. C. Appointing an officer to inquire into, the forest settlement officer to inquire into and determine the existence of nature and extent of any right alleged to exist in favor of any person in or over any land comprised within such limit or in or over any forest. Extension. For the purpose of clause B, it shall be sufficient to describe the limits of the forest by roads, river, bridges, or other well-known or readily intelligible boundary. The officer appointed under clause C of subsection 1 shall ordinarily be a person not holding any forest office except that
So
of
what
forest.
is the nature of the land?
My Lord, nature of the land as recorded, my Lord, is Avajyogya Anuvaji. And that is, I will demonstrate from the annexures, my lord, that their revenue department has categorically told that there is no forest growth.
What is the actual position?
My lord,
What is the actual position?
for last, my lord, so many years, it is being leased out for a quarrying operation.
That you have stated in your petition, but it is not recorded as forest.
No,
Never recorded also.
no.
Because as per the decision of the Supreme Court in that Godavaram case,
No.
once it is recorded, then
That also, I will, even DLC has is a participant in survey report where it is not described as a forest.
What is DLC?
PLC district.
District level committee, my lord, after the
Oh, district
Godavaram,
level
my lord.
Yes.
Well, your lordship knows, after the Godavaram, the question was whether it is, even if a bush is there, it will be recorded as a forest. And the DLC will identify that land and prepare a district survey report. So
whether section 4 notification has been issued?
So section 4 has been issued.
So what is the consequence of section 4?
I am taking, my lord, section 4, 5 is the bearer of accrual of rights after issuance of section 4. This is the prohibition. Your lordship may kindly have a glance.
Yes.
After the issue of a notification under section 4, no right shall be acquired in or over the land comprised in such notification, except by successor or under a grant of contract in writing made or entered into by or behalf of the government or some persons in whom such right was vested when the notification was issued, and no fresh clearings for cultivation or for any shall be made in such land except in accordance with such rules as may be made by the state government in this. So the right which is that may be private lands inside the notified area. So those rights will continue till it is divested by way of land acquisition, for which an elaborate procedure has been prescribed. Then, my lord, the final notification will be made, my lord, under section 20, my lord.
No, but final notification has been issued.
No.
No, just a minute. It says, section 5, no fresh clearings for cultivation or for any other purpose shall be made in such land in accordance with such rules as may be met by the state government.
There is no question of any clearing for cultivation or for any other purpose.
No, for any other purpose.
That is right. For no question of clearing for cultivation or for any other purpose.
Yes.
But it is being used as a quarry.
It is being
used as a quarry. At the time of notification also,
yes,
it was being used as a quarry. And after the notification also, it continued to be used as a query, and the lease has been granted. Not only this.
So what is the meaning of no fresh clearings?
No fresh clearing, you cannot denude any forest.
No question of denuding the forest. Even if a land which is not a forest can be declared as reserve forest.
Yes.
If the nature of the land is not forest, even then that land can be declared as a reserve forest.
Reserve forest will come, declaration will come under section 20.
You are right. But what section 3 refers to not only forest land, but it refers to any land, forest land or wasteland.
Yes, it is neither a wasteland nor a forest land.
What is the definition of wasteland?
Well, wasteland will be not defined under the act. It will be deemed to be a dictionary meaning.
4 says any land.
Any land. So it is not, therefore we are saying that any land can be declared as part of reserve forest.
Right, right. Under that
By
no-
applying,
there is no,
and once the notification is
Yes.
issued, irrespective of the fact whether that land is in the nature of forest or not, the restrictions under section 5 shall apply. The restrictions include no further
but the
clearance.
government case is that it is that is a prohibition under the Forest Conservation Act.
See, the state government
Yes, ma'am.
might have taken whatever plea, valid or invalid.
Right.
But
Let's forget it.
once the matter has come to the
All right,
court
all right.
that there is a notification,
All right.
whether
All right.
the court should entertain your claim
Yes.
for mining. That is
And
the
I
query.
have no-
That is the question.
No right. I am getting.
No,
it.
you can enforce your right based on the agreement or whatever lease.
Section 20 or
Then was the notification issued under section 4?
71.
When was the notification issued?
71.
1971. And so far they have not
They are
issued
there.
notification under section 20.
Yes. Section 20, when the following events have occurred, namely the period fixed under section 6 for preferring claims has elapsed, and all claims, if any, made under the section or section 9 have been disposed of by the forest settlement officer. If any such claim has been made, the period limited by section 17 for appearing from the order passed on such claims has elapsed, and all appeals presented within such period have been disposed of by the appellate officer or court, and all lands, if any, to be included in the proposed forest, which the forest settlement has under section 11 elected to acquire under the Land Acquisition Act 1894, had become vested in the government under the section 16 of this act. The state government shall publish a notification.
So
in
whether
the
section
official
6
gazette.
section 6 steps were taken, section 6, section
No,
7.
no.
My lord, only the forest people can say this, my lord. Whether there is notification or not. my lord.
Forest is a party.
Forest, no, he is not a party.
Implead him.
No, during last time your lordship told that it is formal because they would appear. Your lordship remembers.
Yes, yes.
Last time.
So who is party?
Mining officer.
Mining officer, because the forest department never communicated anything to us. They communicated it to
No,
the
but what is the system of impleading parties? Have you impleaded state of Odisha as party?
Yes, yes.
State of Odisha through whom?
In any view of the matter, from last
mining.
time I have given that information.
Lordship, kindly see
that IA is there before your lordship.
page 78 of the impugned order, man. Page 78, man.
No. Where is the interlocutory application?
Introduction, IA flag D, my lord.
IA is there. IA number.
Flag D.
Flag D.
Just a
D.
Flag D, sir.
D.
Yes, I have 12428.
Yes, we are allowing it.
Well,
IA number 12428 of 2024 has been filed to implead the Department of Forest, Government of Odisha, and Divisional Forest Officer as opposite parties number 7 and 8 to the writ petition. So stop. After having considered the counter affidavit, we are of the opinion that for proper adjudication of the case, the stand of the Forest Department, Government of Odisha will be essentially required to be considered. First off, accordingly, this application is allowed. Let the Forest Department, it's Forest Department simply.
They would also represent the
No,
forest.
department, what is the name of the department?
Department of Forest and Environment.
Forest environment and climate change, man.
Forest, Environment, Climate Change.
The let the secretary, environment, forest, environment and climate change, Department of Odisha, and the divisional forest officer.
No, divisional forest officer.
Divisional forest officer, not revisional forest officer.
Divisional.
Divisional forest officer, Cuttack Forest Division, be implemented as response number
4, 5 or what?
7 and 8.
7.
Right.
7 and 8. This application is allowed.
Well, 6 and 7, man.
6 and 7.
7
and 8.
मोटे तो जो कॉपी दे क्षेत्र नहीं है
6, 7 and 8. It has been mentioned in the application 7 and 8. Stop.
अरे नहीं ब्राह्मण तो जो शीत को से रजिस्टर करते हैं
let necessary amendments be made in the cause title of the writ application. Stop.
Cause title also I am filing.
List this case on 1 week. 1 week, Mr.
Let them take instruction in the next week because my.
Yes, yes,
1
we
week,
are
that's where
adjourning.
he said 1 week.
1 week, we will take up the matter as the first case. All right, as has been listed today.
Consolidated cost title and
Serve him a copy also.
receipt, man.
File in the file in the
Incorporated properly.
file in the registry.
Madam, may I pray? Let it come on 4th.
4th. All right, 4th.
4th October.
4th October. 4th is Friday.
Thursday you won't
No,
be there?
4th is not.
Thursday we
Here,
can
here.
take up.
Mr. Mahanti, this side.
September.
Oh, sorry, sorry.
First. Not third?
Thursday.
Thursday, 3rd October.
All right. Oblige.
Please try to get instructions because if anything has to
Within
happen.
first 5 cases.
Case admission item number 2.
Just a minute. Let an affidavit be filed.
Mahanti.
Let a counter affidavit be filed on behalf of respondents number 7 and 8 in the meanwhile.
7 and 8, man.
Yes.
Case admission item number 2.
May I please, Your Lordship?
Copy nahi.
Input order is at page.
Are you unwell? Are you unwell?
No.
Why is this posture? You are sitting in the front row. Yes.
At page 13 is the input order.
Yes.
Lordship.
Cost paid.
Yes, yes. Yes, my lord. I am appearing for the respondent number 1, my lord.
Yes, yes. It was there yesterday.
My lord.
The associate was asking for time.
Your Lordship, paragraph 4 of that order. Be that as it may, while allowing this petition, this court directs the appropriate authority of each party to grant the benefit of RSP rupees 6,000.
Mr. This will have to be remanded.
My lord.
this order will have to be, the matter will have to be remanded because it was decided on the
My
very
lord,
first day.
in this case, what happened, my lord? The
We don't
initial,
know what happened. They had a right to file an affidavit that was not given to them.
First date has been disposed of, so it will be remanded, it will be decided again.
In the matter, my lord, one, if my learned friend will satisfy my lord that he is entitled to, I will sit down.
No, why should we go into that aspect? You are disputing, that will be decided. We are not-
so far this case is concerned, my lord.
Mr. Counsel, whether you have right to be heard or not,
Yes, my lord.
did we issue notice to you?
My lord.
Are we hearing you?
My lord.
They had also a right to be heard. That is the only thing. We could have set aside the order having been passed on the very first day and remanded the matter back. But still, we impose cost, 46,000, 15,000.
But that cost will go to my client.
For condonation, and that goes to your client.
Yes, my lord.
Client should
Yes,
go
my
to the
lord.
client.
The state of Odisha has put to challenge in the present intra-court appeal an order dated 9/8/2021. 19/8/2021 passed in WPC number 23389 of 2021, which reads as under. Stop. When AGA, appearing on behalf of the appellant, has submitted that the respondent is not entitled to the grant of benefit of RACP, third RACP with effect from 8/6/2015.
Yes, ma'am.
First off, he has further submitted that the impugned order was passed on the very first day when the writ petition was taken up without giving the appellants an opportunity to refute to deny or accept the pleadings in the writ petition. Stop. Next, after having gone through, just what is the date of the order?
That 19/8,
The
2020.
writ petition was filed on 9/8/2021 and was listed for the first time on 19/8/2021. Stop. It is not apparent from the impugned order that any learned state counsel was appearing and was given an opportunity to address the case of the estate. Stop. Next, in such view of the matter, we are inclined to interfere with the impugned order on the sole ground that the same was, whether a copy was served on you, copy of the writ petition?
Copy was served. The copy is served because there is a copy in my file that is a state.
All right. On the sole ground that the state of Odisha and its officials were not given, did not have the opportunity to controvert the pleadings in the writ petition. Stop. The impugned order is accordingly set aside. WPC so and so. Resultantly, WPC so and so stands restored to its original file. Stop. Next, the estate shall have liberty to file a counter affidavit, which Mr. Kuria says will be done within 2 weeks from today, within 4 weeks from today. Stop. Let WPC number so and so be listed before appropriate bench. Third so and so.
Item number 3.
Item number 3, I am appealing for the respondent. Today I am filing my counter. On 18 days, soft copy of the receipt, I filed the counter, madam. With soft copy.
Where is the petitioner?
State
for the appellant. State is the appellant.
On 18, they have soft copy. I filed the
Item 3 also.
next week on taken up
Why are you filing counter affidavit in writ appeal?
because of some
Because of some development.
no, because of all the other cases, they have complied the order. Therefore, all the orders only I annexed of my
It's an
lords.
affidavit, not a counter.
Yes, only affidavit. Sorry, only criminal affidavit, not counter.
An affidavit has been is going to be filed on behalf of the respondent in course of the day. Upon serving a copy thereof on London State Council representing the appellant, stop list this matter 1 week.
Item number 4.
Yes, please, Your Lordship. Order of reversion from the post of assistant director to the position of a programmer was on the ground that the petitioner before the single judge had produced a certificate from a university which was declared fake, was assailed before the single judge on the twin ground. One is that the certificate which was produced from a university which was declared as a fake university much later, that is about 10 years later after I had acquired the certificate. And the second, more importantly, the said qualification was not a prerequisite for getting the post that I was working in. And this challenge was accepted by the learned single judge. He quashed the order of reversion. But while doing so, he has not restored me to the position that I was. He has restored me to one position below that. So that is what I am assailing.
Very difficult to.
Ms. Rath was doing a similar case, I think.
This is the
Same case.
Same. This is the matter she was arguing before the learned single judge.
Here also she was
Very.
before us. I mean, maybe.
Then it may have been another person.
Very difficult, Mr. Mukherjee.
Now, Your Lordship, may I kindly see.
We may take a different view altogether.
My lord, I am not on that certificate which is
Certificate. Certificate.
No, that certificate is a sine qua non. Is not a prerequisite.
Even
I
then,
had acquired such a qualification.
even then, whether that certificate was considered for the purpose of your selection or not.
No, it was not.
All
It
right.
was not.
So even then, you misled this
My lord,
selecting agency.
I got an appointment in 1998. The university was declared to be a fake university in the year 2006.
All right. So is this your, and can you make this submission that before 2006, because there was no declaration, therefore it was not a fake university?
It was. I bow down to the fact that it was. It is a fake university.
It's a question of not within knowledge. It's a question from the very inception.
If it is a fake, it's fake from day one. It's a fake from day one.
So you cannot take this plea.
No, I am
that
not.
it-
I am not
that,
relying.
that fake notification has prospective effect.
No, but it was declared fake in 2006. It may have rendered the entire all the
If you
degrees
want to-
which
if
they
you
have
want to-
granted as honest in the eye of law.
If we
The
don't know,
question is,
Mr. Mukherjee, we don't know what we'll do, but if you press this appeal, we will see.
Well,
whether-
your lordship may examine this. Well,
We will examine. We will examine it there.
Yes, yes.
Press it.
Uh,
Press
well,
it.
Yes.
We are here.
Well, it's your lordship, the appointment order is at page.
Let us see the order.
The impugned order, man.
Yes, yes.
The impugned order is at page 54, is the operative portion. It starts at page 45. Paragraph 4, your lordship may take first.
Page 40.
Page 47.
Yes.
Learned senior counsel appearing for the petitioner contended the petitioner on being found suitable was appointed as against the post of programmer cum training officer Keonjhar, while order of appointment issued on 6/1/98 under annexure 2. Now here, my lords, may I pausing here for a minute. The qualification that was required of me was a Bachelor of Engineering degree, which I had from a competent university. Thereafter, my lords, it is contended that while so continuing, petitioner on being found suitable was adjusted as against the vacant post of system analyst by
All right, we are issuing notice. They will have right to file.
As your lordship pleases.
File cross appeal. Issue notice to. You accept notice.
Take notice for all the.
Yeah, all are still.
This matter on. Soon after holidays, the respondent shall be at liberty to file cross appeal in the meanwhile.
that your lordship may leave to them. If your lordship, if your lordship makes that observation, if your lordship makes that observation, balance, I am being put to a very disadvantageous position.
Delete that.
Such an observation from your lordship would. Okay.
Item number 5.
Lordship, sir, please to appoint as
yes.
We have prepared the report. Suddenly we found some typing mistakes.
All right.
Within 10 minutes you can give it, but last may pardon us. We have
no, but see, we had issued two directions.
Yeah.
One, you to visit, and two, before you visit, the district magistrate was asked to remove the encroachments which are there.
But I will explain that. But so far as removal of encroachment by the collector, district magistrate, because there are encroachments which are also find are not temporary in nature. Some permanent constructions are there. And second thing, we talked to the collector. He says that because it's the entire land belongs to GA department and it's under the control of ASI, he cannot on his own demolish. Only after any order passed by the lordships, there has to be a team comprising of the GA department, municipal corporation.
Who is appearing for the estate in this case?
State, I was appearing.
All right. So it is the policy of the estate that they shall not remove permanent structure.
No. They will do it.
Encroachments.
No, they will.
One has one for the sake. Ensuring that the encroachments are not removed, the encroacher should make permanent encroachment. Sir,
they will remove it.
All right. We will see. So is the place worth visiting?
Yes.
All right. We will do that.
Yes.
And
once your lordship see our reports, also the
we will see your
videographs
report.
and
When will you?
We will see the caves
No,
also.
within 10 minutes.
No, not today. Say tomorrow we can. Tomorrow we will try.
Plus,
Tomorrow
one thing we may be pardoned because we are submitting the report directly to a lordship without going through the paraphernalia. Normally, I should have done it before the register, then it could have been tagged. But we'll give it to a lordship directly, Milords. That lordship may accept.
All right.
Today you'll give it?
Yes, we'll ready, Milords. Only small corrections we will do it.
So all right, better you do it. Better you do it. We will take up the matter on Monday. Monday.
My lord, may I pray one thing, my lord?
Just a minute. Huh? On Monday we can take up. And meanwhile we shall go through the details. Yes, Mr. Padi, yes.
Well, my lord, the ASI is the custodian of the property and he is looking after all these things, monument, all these things. So whatever report my lords may peruse it. If the copy can be given to us, then we can
be given to you.
Once your lordship direct, we can give copies. Otherwise, it's a lordship's direction. So,
it is stated that Mr. L. Samantraya and M.S. Patnaik had visited the site.
Site caves.
Visited the
What are they called?
Khandagiri caves.
Khandagiri
caves.
Pursuant to this court's request recorded in the order dated so and so. Stop. It is they intend to submit the report today itself. Let the same be done. Stop. Let a copy of the let copies of the said report be given to the petitioner, learned counsel for the petitioner, and learned Deputy Solicitor General who represents the Archaeological Survey of India.
I want to intervene in this case.
Intervene, we will see later.
You file the IA, it will come.
Intervention for what?
Because there are two Barabucha temple.
You are encroacher or you are? Are you an encroacher? Are you an encroacher?
Not encroacher, my lord, it is recorded.
Yes.
All right. All right. That will be seen, not in the present proceeding. We will not see that in the present proceeding. We will not do that. If they initiate any proceeding for removal of encroachment, you may appear before them, not before this court. This is made clear.
That trust is recommended by the government also. And it is approved.
That they will be doing. You can challenge their action. You can challenge their action. Not here, not in this.
They will do in accordance with law. You will also proceed in accordance with law.
My lord,
everyone shall proceed in accordance with law. Understand? Not here in this PIL. No.
Not here.
Don't do. And if you do, you know what will happen.
My lord, I have had. The ancestral, the cave number 8 and 9, there are Barabucha, Thakurani and Mahabir already hosted.
See, Mr. Please understand this, that the Chief Justice is not sitting at the filing counter. So you can do whatever you want to do without telling the Chief Justice. The fate, we don't know what will happen after you file.
My lord, I have find a small note for your lordship.
All right, good.
So this will be called, my lord, next week.
Yes, Monday.
Item number 6.
Sir, Jainal and CC is there, he can collect from the same from the Mr. Jain.
Yes. Yes. Yes, please.
This item number 6 is a PIL for the standardization of national emblem to avoid its misuses and criticism, which will lead our nation for the technology guru as well as the artificial intelligence technology hub for across the whole world.
So what is your qualification?
सर मैं उसको हिंदी में थोड़ा सा बोलना चाहूंगा सर।
हाँ, क्या क्वालिफिकेशन है आपका?
सर मेरा इंजीनियरिंग किया है, मैंने इंस्ट्रूमेंटेशन ऑटोमेशन इंजीनियर हूँ।
कहाँ से इंजीनियरिंग किया?
जी सर।
कहाँ से किया इंजीनियरिंग?
सर मिट्स कॉलेज रायगढ़ से किया है।
क्या?
तो अभी मेरा जो प्रोफाइल
तो आपने कहा कि वो मिसयूज होता है नेशनल एम्ब्लेम का।
जी सर।
आपने तो गलत लिखा अपने रिट पिटीशन में।
सर एक्चुअली वो मेरा एडवोकेट जो है उन्होंने लिखा था, जैसे कि इन पर्सन मैंने किया है।
तो आप फ्रेश फाइल करिए, अदरवाइज वो तो आपके खिलाफ एक्शन हो जाएगा।
वो मैं एक्सेप्ट कर,
क्योंकि एफिडेविट तो आपने किया ना। आप पहले देख लें आपका बोनाफाइडी क्या है, क्योंकि आप तो बहुत सारा गलत सरस इसमें लिखे हुए हैं रिट पिटीशन में।
वो मेरा एडवोकेट ने किया है।
एडवोकेट को ऐसे नहीं करना चाहिए, एडवोकेट को ब्लेम नहीं करें। आप
आपने साइन किया है, सो एडवोकेट को मत ब्लेम कीजिए। आपने साइन किया है ना पिटीशन, सो देखना चाहिए था।
आप तो क्वालिफाइड आदमी है ना, आप तो इतने ज्यादा क्वालिफाइड हैं। यू फाइल एन एप्लीकेशन, वी विल सी योर लेवल आल्सो, whether you are very serious about it or not. We have to respect everyone has every citizen of India has a duty to, but what you have done, do it.
जो मुझे डॉक्यूमेंट दिया है मैंने उसमें कर दिया है। जो
देखिए
document
आपके इस पिटीशन के बेसिस पे ये अच्छा नहीं लगेगा कि वो डिसाइड करें इशू, क्योंकि ये पिटीशन बहुत गलत तरह से फाइल किया हुआ है।
सॉरी सर, मैं उसको ले लेता हूँ।
आप ले लें, फिर फाइल करें, फिर आप मेंशन करें, फिर देखेंगे।
तो फिर से फाइल करना
वो तो करना पड़ेगा। अगर आपको कोई एग्जाम्पशन चाहिए फी से, तो विल सी
लास्ट 4 इयर्स से मैं कोई जॉब नहीं करके डेडिकेशनली इसको पूरा देश।
ऑलराइट, वो भी जॉब करना भी नेशनल इंटरेस्ट में है। आपका जॉब करना, आपका काम नहीं करना, वो नेशन के खिलाफ है, वो पब्लिक इंटरेस्ट के खिलाफ है। इसलिए आप काम भी करें, आप अर्न भी करें, आप फैमिली को भी देखें, ये भी एक ड्यूटी है। ये सिर्फ आप सत्यमेव जयते इसमें है, वो सिर्फ इशू उठाने से नहीं होगा, सत्यमेव जयते अंदर से करना होगा।
तो उसी के लिए
तो ये तो बड़ा मुश्किल है कि आप 4 साल से कोई काम नहीं कर रहे हैं, सिर्फ यही कर रहे हैं।
ये इम्पोर्टेंट
तो
इशू
आप
है।
तो समाज के लिए बोझ हैं, और आप पब्लिक इंटरेस्ट लेकर चले आए।
इम्पोर्टेंट इशू है, इसलिए इट इज इम्पोर्टेंट दैट ये पिटीशन को आप ठीक तरह फाइल कीजिए, ठीक चेक करके कि कुछ गलती ना हो। और
आपके पास जो पिटीशन है वो मेरे पास अभी आया नहीं है, वो आएगा तो मैं कर दूं। मेरे तो जो हैंड आउट किया ना इसमें मैंने कर दिया हूँ मेरा। तो
चलिए फिर अभी नहीं इसमें
इससे नहीं होगा, इससे नहीं होगा
जी।
और एक फाइल कर लीजिए।
एनरोलमेंट कर लेता हूँ, फिर नया करना पड़ेगा फिर से।
आपको नया करना पड़ेगा, तो आपको कुछ नहीं करना है। वो आपका जितना एग्जम्पशन है, आप फाइल करिए, किसी वकील साहब के यहाँ जाएंगे, वो टाइप का या आपको सारी सुविधा मिल जाएगी।
सर एक छोटी सी रिक्वेस्ट
कुछ छोटी सी रिक्वेस्ट नहीं, यहाँ पे हमारा समय हमारा भी बहुत इंपॉर्टेंट है। आप इन पर्सन अपीयर हो रहे हैं, इसलिए इतना डिस्कस कर रहे हैं। आपको जरूरत होगी, आपको लीगल एड दे दिया जाएगा, कोई पैसा नहीं लगेगा आपको, ठीक है। आप लीगल सर्विस अथॉरिटी यहाँ पे है, आप वहाँ जाएं, आप कहें ये करना चाहते हैं, मेरे पास पैसा नहीं है, दे विल डू एवरीथिंग। समझ गए?
सर इसमें
Counsel appearing on the petitioner in person, after having noticed patent discrepancies in the drafting of the present writ petition, seeks permission to withdraw this writ petition with a liberty to file a fresh writ application. This writ application is accordingly dismissed as withdrawn. Stop. The petitioner has stated that he does not have sufficient resources to file another writ application. So stop. He shall be at liberty to take legal aid from the Odisha State Legal Service Authority. Odisha State Legal Service Authority. ठीक है।
Item number 7.
Yes.
Yes. The petitioner is a bidder, was participating in the bid, and its technical bid has been rejected only on the ground that the is blacklisted. So lawsuits are looked to page 26. Page 26.
Item listed at item 24, that is involves the same thing. Item 24 is also of the same petitioner. Same issue.
That the difference is that here they have raised a claim stand that at the time of filing the last date of submission, the blacklisting has not been listed. This is the
How many
question.
cases
Here,
have you filed?
In the 28, the another that is within the period is blacklisted. That's the question difference.
But same issue.
No, 24.
Same
No,
issue.
28.
28.
28, sorry.
28.
Last. 28, sorry.
Yes.
We'll take up both the matters together.
You can take up.
We'll take up both the matters together. Same file that has been filed by the same petitioner.
Yes.
That in this case, the counter is under everything is filed. But here
Counter is?
Counter is under everything is filed in this item 20.
Last one.
Yes.
So this also we can consider together. We can take it up. It is good for you. Others might 28 may not have reached today. So we can take up both.
Let this let the matter be taken up along with WPC number
19492.
19492 of 2024. Taken up together.
We'll post both to another date. So you please wait.
Yes.
Item number 8.
My lord, in this case, my lord, present petitioner pray for the allowing the students, my lord, for the admission of the industrial training center. One matter is pending, my lord, because your lordship directed to mention and today this matter is listed, my lord. Other cases, your lordship passed this order, my lord, allowing the students for the admission. The common order passed by the DTET, my lord, on letter annexure 7.
List this matter along with WPC?
WPC number 23213, my lord.
And batch.
Yes, ma'am.
That ITI matter, no?
Yes,
Your Lordship. It's been posted to 3rd of October, Your Lordship.
On 3/10/2024. Interim order जो वहाँ पे
Interim order continue.
Interim order is there in this?
Yes, ma'am. No, that is a press case, ma'am.
So why you say continue?
No.
Yes.
That old matter.
Interim order in that?
Yes,
In
ma'am.
those cases, Your Lordship has said, and finally the Lordship.
Yes.
That case number.
No, it is
case number.
Kindly.
Like 23231, maybe that IIT matter that will not have the interim order.
ITI.
No,
Sorry,
that IT matter. That is
That
yes.
will not have the interim order. So give one order.
Yes.
Last May. Interim order.
The number
Interim order is no course.
Last date of admission.
is what council should find.
केवल
Yes.
199.
Yes.
only one matter today, madam.
191.
24. 19924.
Interim order, madam.
Yes.
For admission item 17.
May I please your lordships? And that this is an WPC public interest litigation challenging the order dated 25th November 2022 passed by the collector Sambalpur, your lordships. In pursuance to the order dated 19th September 2022 of this honorable court, your lordships. Here the honorable court has directed to pass and reject order after hearing both the parties, that is BPCL, opposite party number 4, and the villagers also. My lord, without hearing the parties, they have passed the order, and which has been annexed as
41. Annex 7, page 41.
annexed 7, my lords. My lord, opposite party 5
So where
has
is the order of this
filed
court? Where is the order of this court?
The previous writ application?
Yes, ma'am. That
Yes, your lordship.
Okay, so where is that order?
That is WPC 21609 of 2022.
Where is that order?
Your lordship, I have not annexed that order.
Then
Not annexed, not quoted also?
Yes, we have quoted that also.
Where?
Not quoted.
Your lordship, on the first para, your lordship.
You know the meaning of quote?
Yes, lordship. In particular, I have not quoted, but I have mentioned the substructs also.
it's very difficult. You file a PIL, you get that disposed of with
Your lordship,
order for disposal of your representation is disposed of, and then you
Your
are
lordship,
challenging
in
it on the
Annex
ground
7
of
also they have
violation of
mentioned.
principles of natural justice. Let us see the order.
Your lordship,
When your specific ground is that the directions have not been followed, should you not have filed a copy of that order?
apology for that also, your lordships. But in Annexure 7, they have mentioned, they have quoted that also. Para 2.
Deficit court fee of ₹54.
Your lordship, we have submitted it today only.
What, the deficit court fee or the order? What?
Deficit court fees. Your lordship.
No, we shall not interfere in such matters.
Your lordship, here the scenario has been changed since filing of this PIL. Your
Okay, deposit deficit court fee.
Your lordship,
Just a
they
minute.
have made the construction.
Pay deposit the deficit court fee first.
Yes, your lordship.
The deficit court fee shall be filed today as undertaken by learned counsel for the petitioner. She also undertakes to file a copy of the order passed in WPC number
21609 of 2022.
21609 of 2022.
22.
This is the case on.
I have a small prayer, ma'am.
Yes.
Let the government take instructions. They are not issuing.
You don't know, these are unnecessary.
They are not issuing NOCs, my lord, because of this pendency of this writ application.
We will take up. We will take up the matter.
Monday.
Obliged.
We listed on Monday, madam.
Obliged.
Number 18.
No, if the order is not, the same shall be stand and incorporated in the digital record. If they don't do it, again it will be adjourned.
18, my lord, pass over, my lord.
No, in fact, my lord, in this case, my lord, the pleadings are completed, but the petition has not submitted the entire tender documents. So let him file the entire tender documents so that the honorable court can also refer the petition clauses, my lord, because it is required, highly required.
Pass over, my lord. On behalf of Mr. Das, my lord, he is in legs, my lord. Kindly pass over. On behalf of Mr. Das, my lord, and he is in legs, my lord. Kindly pass over.
On behalf of the petitioner, this matter on Monday. Stop. In the meanwhile, let the tender documents be brought on court.
Smile.
Please file it in course of the day so it can be brought on record. All right.
Course of the day, my lord.
You don't have the file.
Well, file it. Next week, my lord. Within a week, I will file, my lord.
Yes.
Item number 19.
It is.
Yes.
I'm appearing for the private opposite party. So Naidu was appearing for the petition.
So for the time being, you can argue on his behalf. Let us understand. Yes. So what is the case about?
Lord, if I may be permitted, so Lordship leave. Lord, this is a case where a tender was floated by respondent number 1, Mahanadi Coalfields, for the purpose of extracting coal from a mine. Milord, I appear, Milord, in the case of BGR for the respondent number 2, who is the successful Milord tenderer L1, and my friend appears in the NCC, which is Milord listed as 1 today before your lordships. Earlier, Milord, BGR was the first.
Again, he is for the respondent.
Respondent number 2. Respondent number 2.
Same
Respondent number 1 is represented by the learned additional solicitor general, who will be here shortly. And so the case, the tender was floated. There were 8 persons before the bids were submitted. There were queries and clarifications. 8 bidders had come at that time. Thereafter, Milord, when the bids were submitted, only 3 persons submitted. So the 2 petitioners before your lordships, and Milord, it was I had also submitted. Thereafter, the bids were examined on a technical basis, and on the technical basis, it was found that their bids were, Milord, deficient for certain false statements having been made and certain suppressions. Based on that, Milord, they were disqualified for the purpose that they will not go further for any evaluation. Milord, then on the Milord, our bid was accepted. The price bid was opened. Then after the price bid was opened, Milord, I was a single bidder, of course. And after price bid was opened, the price was negotiated. After the price was negotiated, Milord, the letter of acceptance was given to us. A writ petition was filed before your lordships. An interim order was passed on 25th of May 2023 by your lordships, Milord, whereby it was ordered that the process of the finalization of the tender may go on, but the awards may not be made. That writ petition was ultimately dismissed, Milord, by the division bench on 19/12/2023. Thereafter, Milord, SLP's specially petitions were filed in the Supreme Court in the month of March 2024. Those, Milord, were allowed by 2 separate orders of 26th April and 6th of May.
Yes.
And Milord, the Honorable Supreme Court, Milord, remanded the matter back to your lordship for a fresh consideration. And therefore, this is how, Milord, the matter is here. Thereafter, my friends had filed an amendment application. That amendment has been allowed. And after the amendment, Milord, counter affidavits have been filed and the pleadings are complete. That is how the matter arises. Now,
yes.
So,
you are for whom?
I am for the MCL. Solicitor General will be appearing. Additional Solicitor General will be appearing.
So he was there online, please ask.
No, he is not online.
Oh, sorry. I'm sorry. I'm very sorry. It is the DSGI.
Sorry.
I think he has come in person.
Yes, he has come very much here.
He wanted to finish some matters
to have
and come.
some matters on virtual mode before the Supreme Court, because additional Solicitor Generals are also very much.
I think he thought that it will be taken up at 2 p.m.
No, we had.
Your lordship had made it very clear that if not taken up before lunch, it will be taken
Then we will make accommodation.
Because at 2 p.m. we have a different bench.
That is
your lordships are sitting singly dealing with some Section 11 applications.
Yes.
That's
so
what
therefore, because all of you we had decided that
Very
if it is
obliged,
not
very,
taken up in
very
the first
grateful.
half, we will take up, we'll
Very
sit
grateful
after.
for the accommodation, my lord,
So-
and the indulgence. So if your lordship want, I can take your lordship to the
Yes, we
tender
can-
conditions.
we can-
I will not,
begin.
other than the tender conditions, I will not, try to,
Yes,
in
yes,
any
yes,
way
yes.
prejudice, my lord.
You are a fair counsel, senior counsel, we know.
Mr. Rao is also
Right.
appearing for one of the petitioners, means in one of the cases. He is the petitioner in one of the cases, Mr. Naidu is counsel in the other case.
So, my lord, if your lordship permit me to deal with, my lord, read petition 17120 of 2023.
Second one. Okay.
17120.
Yes.
17120.
And my lord, the terms and conditions of the bid, of the document, my lord, are at page number 70, the NIT, my lord, at page 70 of this paper book, annexure 7.
Just a minute.
Second.
Just.
May I, sorry. May I, my lord, place it, my lord, at page 70, dated 17/11/2022.
Just.
The Mahanadi Coalfield Limited is engaged in the development of operation of coal mines, and as part of this endeavor, the authority has decided to undertake the development and operation of the Balbhadra OCP, my lord. It is open cast project. OCP stands for the open cast project.
Yes.
Through a mine operator for excavation of coal and delivery thereof to the authority.
Yes.
Then, my lord, thereafter, this is Mahanadi Coalfield is a subsidiary, my lord, of the Coal India Limited.
Yes.
Pursuant to this NIT, the authority invites digitally signed and encrypted bids on a single stage two-part bidding process on the website of such and such from reputed and experienced bidders for the following work. And if I may just give the description of the work in the first column: development and operation of Balbhadra OCP as part 2, scope of the project of contract agreement and other requirements specified in the contract. Location of the project is Talcher Coalfields in Angul, and the estimated project cost is 1,274.90 crore. This is the person who will bid would need to invest for the purpose of the mine, and the bid security was 2 crores, and the duration of the contract is for
2 crores or
27
200?
years.
2 crores.
2 crores, my lord. Bid security was 2 crores, and the duration of the contract is 27 years.
Yeah. Yes.
Now, my lord, now, my lord, thereafter, my lord, I will just show that the document, my lord, which is the request for bid at page 86, which contains the conditions. If I may request your lordship to kindly have page 86, which is an attachment to the notice inviting tender.
Page 86.
At page 86, my lord, development, operation, etc. And then, my lord, your lordship will find, as your lordship will just have, because here is a case where what has happened to my friend's cases is conflict of interest. So, my lord, that is defined as mentioned at page 87 in the glossary, about the later part of the middle, just below contract agreement, conflict of interest as defined in such and such.
Which page?
Conflict of interest.
Which page? Which page?
Page 87. I will take your lordship to 2.21.
Yes.
2.2.1. I'm just showing from the glossary, it is so defined. Just about the middle, my lord. Just below contract of agreement.
Yes.
My lord,
2.2.1b.
Yes, my lord. Now, my lord, if I may request your lordships to kindly come to page number 99 about the eligibility, my lord, of the bidders. Eligibility and qualifications, it starts from 98 under the general clause of instruction to bidders, my lord. So I have a few clauses to show, my lord, if your lordship permit me. I will first show, my lord, 2.1.6, which is important. Non-compliance with any of the bidding instructions may lead to rejection of the bid.
Yes.
Then, my lord, over the page, 2.2.1 is eligible bidders. A, my lord, is bidders may submit a single bid or a consortium formed by such and such. My lord, we are not really concerned with this. B, my lord, is what is important. A bidder shall not have a conflict of interest that affects the bidding process. Any bidder found to have conflict of interest shall be disqualified. In the event of disqualification, the authority shall be entitled to forfeit and appropriate the bid security or performance security, as the case may be, as mutually agreed, genuine pre-estimated losses and damages likely to be suffered and incurred by the authority, and not by way of penalty, for inter alia the time, cost, and effort of the authority, bracket the damages, without prejudice to any other right or remedy that may be available to the authority under the bidding document and or the contract agreement or otherwise. A bidder shall be deemed to have a conflict. Now, my lord, this is explained. A bidder shall be deemed to have a conflict of interest affecting the bidding process if, and now, my lord, one is important, the bidder, its member or associate, or any constituent thereof, and any other bidder, its member or any associate thereof, or any constituent thereof, have common controlling shareholders or other ownership interest, provided that this disqualification shall not apply in cases where the direct or indirect shareholding of a bidder, its member or an associate thereof, or any shareholder having a shareholding of more than 5% of the paid up and subscribed share capital of such bidder, member or associate, in the other bidder, its member or associate is less than 5% of the subscribed and paid up equity share, provided further, Lord, that part is not necessary for our purposes. And over the page, number 5, my lord. The disqualification has been made by this 5. Clause 2.2.1b5. Small Roman 5. Such bidder
Point
2.2.1.b.5.
Yes.
At page 100. Such bidder, its member or any associate thereof, has a relationship arising due to ownership, holding, cross-holding with another bidder, its member, or any associate thereof, directly or through common third party that puts either or both of them in a position to have access to each other's information about or to influence the bid of either or each other.
Yes.
So, my lord, I am not stating the facts yet, my lord. I am only because I don't want to, my lord, in any way.
Yes.
Then your lordship will kindly come to page number 102, 2.2.4, associates.
Yes.
In subclause small Roman 2, my lord, 2.2.4, small Roman 2, associate is, my lord, also, my lord, defined, and control is defined.
Yes.
For the purpose of this RFP, the expression associate means in relation to the bidder member a person who is controlled by such bidder member. As used in this definition, The expression control means with respect to a person, which is a company or a corporation, that the right to appoint or cause the appointment of more than 50% of the members of the board of directors or similar governing body of such person, or B, ownership directly or indirectly of more than 50% of the voting shares of such person, and with respect to a person which is not a company or corporation, the power to direct the management and policies of such person by operation of law. Then, the Lordship may come to. Kindly come to page 106 now, my lord, under clause 2.6. Lord, it says acknowledgement by the bidder, it shall be deemed that by submitting a bid, the bidder has, and then, my lord, F at page 107, clause F.
Yes.
Has acknowledged. F is acknowledged that it does not have a conflict of interest. So it is deemed, my lord said, that while submitting a bid, the bidder has no conflict of interest. My lord,
yes.
They want, Lord.
Oh, we will rise for a while.
Please, please. Please.
Taken us to this.
Yes, Lord. I was at page 107.
Just we will finish the clauses.
Yes, Lord.
Clauses.
I will do that. I'm much obliged. Very grateful. So, my lord, at 107, I have shown, my lord, that he is deemed to have Lord, it shall be deemed that by submitting a bid, the bidder has acknowledged that he does not have a conflict of interest. Thereafter, my lord, your lordship may come to play, please, at 119, my lord. Clause 4. Because added with 2.2.1 B5, this has also been added for the purpose of rejecting the bid of my friend's client. If I may place it, the bidders and their respective officers, employees, agents, and advisors shall observe the highest standard of ethics during the bidding process. Notwithstanding anything to the contrary contained herein, the authority may reject a bid without being liable in any manner whatsoever to the bidder if it determines that the bidder has directly or indirectly or through an agent engaged in corrupt practices, fraudulent practices, coercive practice, undesirable practice. So what has been stated, my lord, is the order is undesirable practice.
Yes.
And of course, 4.2 deals with that a person can be made, my lord, to suffer, that there will be no black, that he can be debarred from, my lord, a future participation, which was given, a show cause notice was given to them, but later on that was withdrawn as a one-time concession. And what the respondent number 1, Manadi, did was that they said, forfeiture of security we will not allow, we will not give up, but as a one-time measure, we accept your submission that we will not, this debar clause will not apply. Now, my lord, if a lordship see what is an undesirable practice in 4.3D at the foot of that page. For the purposes of this clause 4, the following terms shall have the meaning hereinafter respectively assigned. Undesirable practice means establishing contact with any person connected with or employed or engaged by the authority with the objective of canvassing, lobbying, or so and so, but not concerned. Number 2, having a conflict of interest. So, because the debarment, because they were rejected, they were disqualified under conflict of interest under 2.2.B, 1B. The same, the conflict of this part of undesirable practice was also, mentioned.
So according to you, the conflict of interest falls under the heading fraud and corrupt practices under section Roman 4 of the RFB.
Please. So therefore, so these were the two grounds on which they were disqualified. their security was forfeited, and they were given a show cause notice as to why, my lord, they for future tenders they will not be debarred. And for that, my lord, the show cause notice, if your lordship would like to see the clause, it is at page 111. 2.16.6. So
111.
Sorry, bro.
111.
Yes, at 111.
Yes.
May I place it?
Yes, please.
The bid security shall be forfeited as damages without prejudice to any other right or remedy that may be available to the authority under the bidding documents and or under the contract agreement or otherwise under the following conditions. And number A, if a bidder engages in corrupt practice, fraudulent practice, coercive practice, undesirable practice as specified in section 4 of this RFP. So, Lord, section 4 I have not shown to your lordship at page 190.
Yes.
So they were given this no show cause notice as well, Lord, after forfeiture.
That's all.
These are the clauses, my lord, which are relevant for the purpose of their disqualification. There are other clauses, my lord, with reference to whether a single bid could have been accepted or not, etc. That, if your lordship would like, I can show that.
We can see in the meanwhile.
Please, Lord.
So 2.16.6, the last paragraph says, in addition to this, can be debarred and
Yes,
blacklisted.
I am obliged, Lord, very obliged. In addition, upon the occurrence of any of the above set of conditions, the defaulting bidder shall be debarred and blacklisted from participating in any bids tender floated by Coal India and or its subsidiaries for a minimum period of 1 year from the date of getting declared as debarred, blacklisted. It is further clarified that the decision of the authority in relation to the occurrence of any of the above set out condition shall be final and binding. So this they have withdrawn. And they write in the letter, my lord, it's a one-time concession.
Yes.
Now, my lord, if your lordship will kindly see at 107 regarding the acceptance of the bid, my lord, which is clause 2.7.
Which page?
Page 107.
Yes.
Lord, it says 2.7.1, Lord. Notwithstanding anything contained in this RFB, the authority reserves the right to accept, negotiate, or reject any bid and to annul the bidding process and reject all bids in whole or in part at any time without any liability or any obligation for such acceptance, rejection, or annulment, and without any assigning any reasons therefore. So, my lord, two things, my lord. One is about acceptance, and then there is the second part is about right to negotiate, and the third is about rejection. So here the bid was accepted after negotiation with me, my lord.
No, but where is discussion on this acceptance of single bid?
That is in the financial rules, which in the counter affidavit filed by the respondent number 1, they have quoted that and annexed it, my lord. I will take your lordship to that also. Kindly come thereafter, my lord, on this point at page 113.
Yes.
Lord, if I may just, the evaluation parameter in 3.1.1, only those bidders who meet the eligibility criteria specified in clause 2.2, Lord, which we had seen earlier, of this RFB shall qualify for evaluation under this section 3. Bids which do not meet these criteria shall be rejected. And then, my lord, of course, there is two parts, my lord, to it. The bidder's competence is proposed to be established by technical and financial. And, my lord, for a work experience to qualified should fulfill the stipulations under clause 2.2.2, then experience, etc. And then, my lord, 3.5 at the foot of that page.
Yes.
The bids will be decrypted online and will be opened on the pre-scheduled date, revised scheduled date by the openers of the bid with their DSC. The authority shall open part 1, cover 1 of the bid if at least 3 bids are received. So, my lord, there were 3 bids here, my lord, which were received. Of course, 8 bidders had sought clarification, etc., but only 3 applied, my lord. However, if the number of bids received within the stipulated bid due date through the e-procurement portal is less than 3, then the originally stipulated bid due date shall be automatically extended by 4 days by the e-procurement portal. If even after granting extension as aforesaid, less than 3 bids are received, the bid so far submitted shall be opened without any further extension. No separate corrigendum shall be issued and published by the authority for extending due date. In case no bid is received, the tender will be cancelled. And, my lord, then, my lord, the lordships may come to 3.9. Lord, if I may be permitted to place at 116, 3.8.2 first, and then go to 3.9. May I place 3.8.2?
Yes.
Price bid will be opened after the evaluation of part 1. The part 2 cover of only the techno-commercially acceptable bidders. The bidders who have qualified against part 1 shall be decrypted and opened on this scheduled date and time for which an intimation will be given to such commercially acceptable bidders through the e-procurement portal. On opening of the price bids, the bidders may view the price bid online remotely on their personalized dashboard and can see the price bid submitted by all participating bidders. After opening of the price bid, the comparative statement of prices indicating the rates quoted by all bidders will be generated by the system, and the lowest price bid L1 shall be determined accordingly. In the event that same L1 is quoted with more than one bidder, the bidder having the highest net worth shall be determined as the L1 bidder. And then, my lord, in 3.9 is the selection of the bidder, and your lordship will kindly come to 3.9.2, my lord. Kindly, my lord, over the page. The authority does not bind itself.
Yes, please.
To accept the lowest bid and reserves the right to reject any or all the bids without assigning any reason whatsoever, without incurring any liability to the bidder affected or otherwise, or any obligation to inform the affected bidder on the ground of the authority's action.
Yes.
And then, my lord, 3.9.4, the successful bidder, after furnishing the requisite performance guarantee, shall execute the contract agreement within 90 days from the date of issue of the letter of acceptance through the SPV. The successful bidder shall not be entitled to seek any deviation. So, my lord, this has happened so far as I am concerned. That the letter of acceptance was given to me, contract of agreement entered into, and, my lord, the performance security guarantee given.
Yes.
And, my lord, in 3.9.5, bidders are advised,
Yes, please.
Bidders are advised that the assessment of qualification of bidders will be entirely at the discretion of the authority. Bidders will be deemed to have understood and agreed that no explanation or justification on any aspect of the bidding process or selection will be given by the authority. The authority will not entertain any query or clarification from bidders who fail to qualify. The reason of rejection of unsuccessful bidders shall be communicated online on the portal itself. So this is how, my lord, it has happened, my lord. And it was communicated on the portal, my lord. So this is insofar as the provisions are contained in the NIT and the RFD. So this is I have just shown the relevant clauses, my lord, and I am subject to correction by my friend if they want to show any other thing, my lord. I'm much obliged.
Thank you.
Grateful for the indulgence.
So he was doing your job, Mr.
Yes, yes.
I'm greatly obliged. But the-
Regarding, sorry, my lord, to interrupt.
Okay.
Regarding that, my lord, single bidder and the financial rules, if your lordship would like to have a look at also that and then.
So let them say, because.
Yes, let them show. Nope.
Let them say.
In fact, this 3.5.1, which my learned friend had just placed, that substantially covers, plus what my learned friend says, MCL's counter affidavit, that will be shown to your lordships. Let them
hear
first.
them.
Let them first.
Please.
Let's, before I proceed, my lord, I have a small handicap. Let me point out. Your lords, after the amendments were allowed and the consolidated writ petition was given, and your lordships have directed that all the parties to exchange the counters and rejoinders so that it would come for disposal today at 2 p.m. But unfortunately, I have received the counter of this opposite part number 4 only yesterday evening, and opposite party numbers 1, 2, 3 day before yesterday. I have prepared a rejoinder so far as the.
Is there any interim order operating?
Yes, well, what has happened? There was an interim order by this honorable court stating that no work order should be issued, and thereafter till disposal of the writ petition. After the writ petition was disposed of, that interim order automatically got vacated, and after the honorable Supreme Court has again set aside the judgment and remitted back to this. Our submission is that since the matter has come back to the stage of non-disposal of the writ petition.
Sorry, that is not kind of restoration of the writ petition. The matter has been remanded back. So, fresh, either have you filed any application?
Yes, I have filed an application
for
stating
interim order.
that the stay order to continue, interim order to continue.
You can seek adjournment for whatever time you want, but in the meanwhile, they shall be at liberty to proceed.
No, the prayer made now, the prayer made which they are saying is about that no letter of acceptance or the tender should not be finalized. It's long gone, my lord. Everything is over. The LOA was given. Thereafter, my lord, in December, the judgment of your lordship was passed. On 28 December, I got the letter of acceptance. Thereafter, my lord, I gave the say performance guarantee. Thereafter, my lord, work order was issued. Thereafter, contract of agreement was issued.
The order which was passed in the earlier.
One minute.
If a lordship sees order number 10 dated 13/5/2024 in WPC number 17120. After the matter was remanded back from the Supreme Court, in WPC number 17120, they had moved an application for stay, which a lordship had not granted. If a lordship sees that order dated 13/5/2024,
And your lordship about that. And your lordship sees the earlier order which was passed. It was passed, the work will progress, but no work order will be. But now,
Mr. Rao, you want adjournment?
Yes, because I have to respond to the reply.
All right. He has not made any submission. Mr. Ranjit Kumar has not made any submission.
I was very careful.
Any submission.
No, I'm grateful to him, my lord. There
He
is no
has
difficulty.
just taken us to various provisions of the.
Correct. All the clauses he has placed. The clauses. In the
Clauses, he has
RFP
just
are
placed the
placed.
clauses
Yes.
for us to understand.
But my understanding there was that matter will be taken up at 2 p.m. That's why.
2 p.m. But had you not seen the list that this bench will not function after
Yes,
lunch?
yes, we have seen it in the first.
So everybody was present in the first hour.
See, Mr. Rao, in the morning when the cases were mentioned, we had made it clear.
No, I was present.
If it is not taken up
I was present
before the recess, in the special circumstance that senior counsel have come from outside, we shall take up at 2 p.m. by constituting special bench, and then we clarify that we may take up before. So you could have said then.
No, that's right. I could have.
I may only wish to point out regarding the stay my friend wants, that they tried for the stay in the Supreme Court after the matter was remanded back. And they were not successful in that. And that is also recorded in your lordship's order of 13th May. And while declining the stay application. And that IA stands disposed of.
That has not been challenged.
And that-
So, and much water has flown, my lord.
No, that they what?
Have you started your work?
Yes, I have started with my work, my lord. I have taken loans from the bank, my sanction order, I have annexed the bank sanction order.
we are, in fact, in the affidavit, we have given all the details which we have progressed.
Let us see the Supreme Court's order.
Yeah, Supreme Court's order, my lord. Your lordship will.
You want this?
I have got.
The two separate orders.
Two separate orders in two petitions on two different dates, my lord.
Yes.
The second order just
We
follows
have
the first one.
quoted the orders in the last order, if I remember correctly.
Your lordship is holding the brief of 17120.
Yes.
I think. In that.
I'm giving two copies of the Supreme Court order, sir.
No, BGR.
This is BGR which I am passing on.
17120. That is the main order which.
May I place it now?
Just.
Yes, in our order dated 10/9/2024, we had quoted the operative portion of both the orders.
26th April 24. Your lordship has quoted that. This is
Common order
So there
was
is no
passed.
urgency also in the.
LCC.
No, the Supreme Court has not observed that it should be disposed of.
No such observation is there.
No such observation. is
No
there.
such observation is there, but the question is because the.
No,
earlier there
whatever.
was-
See, we are not imposing anything upon you. You want adjournment. We will give you adjournment.
But I want adjournment because yesterday only I was
No,
given.
no,
that,
but if
not-
you have gone through, do you think it is required? May not be required also, provided you have gone through.
But the question is what they have given, this opposite part number 4 has given, they have given only yesterday evening.
What we gave, Lord, was the subsequent development that has happened.
No, may I point out one thing with
But the learned age is-
Yes, may I point out one thing now?
Yes.
For the petitioner, my learned friend, Mr. Naidu is appearing. Anyway, morning he was there. Just now he called. I think he'll be reaching there shortly. Whatever the decision in the matter, I think in the fairness, let us take in his presence. Otherwise, he'll be in a little handicapped in the matter to say whatever he wants to say.
He's here, Mr. Nataraj, he's here.
Yes. Right, fine. Then.
Is it?
Millets, I'm sorry and I'm clueless.
Sit for a while
I was
and then
given
make
to
a-
understand, I think my friend could vouch for that one, that we would all be here at 2 o'clock. That's why, Millets, I was engaged in another case.
There was some.
Rather, on our part,
we were not
we
able
could not
to
get
convey.
it right.
We were not able to convey what we
No,
wanted
Millets,
to convey.
we could
in the
have taken
morning.
it wrong.
Because we were very clear that we shall take up this matter, especially at 2 p.m. if it is not taken up earlier. So.
Millets, the later learned she has said that because he's been engaged in
Yes, he
other
said
cases.
that, but That's right. it's not.
Then that we thought it would apply across the board. We'd all be here at 2 o'clock.
All right,
Millets.
all right.
That's why they've logged into another case. I could not get the
No
calls.
issue, no issue, no issues on that.
He's asking for.
No issue.
Millets.
We can wait. You can wait for sit for a minute and then make your.
May I request one thing, Millets? Now it seems they know the strength of their case. Let me put it this way. Now they would like to rely on a technicality that we have gone too far. We have spent this much and that much.
No, they have not made even a single submission.
Millets.
Mr. Ranjit Kumar has been fair enough not to make even a single submission.
I appreciate
on the
that,
merits
Millets.
of the.
I appreciate
of
on
the
that
case.
one. Millets, we are now they may take a plea. Let me put it this way: they may take a plea that now we have started. My lords may kindly see what has happened. Initially, there was a direction that The process may go on, but no work order should be given.
Please,
Yes, my lords.
please let us appreciate that what plea he'll be taking, we don't know.
No, my lords, I'm submitting.
So
we have filed an IA. In that context, I'm explaining, my lords. Nothing, I'm not showing an accusing finger. I'm only explaining, my lords, initially there was a stay saying that the first respondent could as well go ahead with its process, but no work order should be given. That held the field until the writ petition was dismissed. Thereafterwards, we went in SLP before the Honorable Supreme Court. It was reversed and remanded. And my lords, a remand in the sense that whatever happened has been set aside vis-a-vis the judgment that's been rendered, but the whole position has been restored. On the last occasion, my lords, we requested your lordships that we have already filed an IA only to preempt their plea vis-a-vis these, my lords, because after the matter has been remanded, this work order has been given lis pendens. This is my humble submission, my lords. It's not a no man's land when they got it, but when the remand happened, that has happened. Last occasion, my lords, I submitted my lords may kindly order either stay vis-a-vis my application or status quo, because they should not take such a plea. That's my request, my lords. My lords, I placed my reliance on Vari Jacob's case, a 3-judge bench decision, where it's been said, my lords, unless the judgment has expressly set aside all orders that were involved until then, it is automatic restoration of interim protection as well. My lords, that's why, my lords, kindly, because the other side I could gather that they have said that they all to join the issue by filing a rejoinder. It's been served on us as well, and I think we have filed rejoinder. We have just filed that, my lords. My lords may kindly accommodate us on next Wednesday. Till then, my lords may kindly appreciate that when it comes to IA, some ruling may be rendered, my lords, because I've relied on Vari Jacob. It's automatic restoration. It can't be otherwise. My lords could see the dismissal order, where it's not been said that the rest of the orders have been vacated. That being the case, my lords, give us protection for a week's time so that we'll get along with this
let us
matter.
see the judgment. It is there in your rejoinder. Where is that?
My lords, on the last occasion, we supplied that one.
Must be there.
That's 2004 6 SEC 378.
No, the judgment is not there. Is it a part of any pleading? Is the judgment part of any pleading, Mr. I do.
No, my lords, it's not. We have just given. My lords, unfortunately, we have to blame on the technology. Otherwise, at least council copy could be passed on. I can't have that advantage.
No,
My
no,
pass it on what's been there.
We can retrieve from our document also.
Yeah.
I can give my copy, my lords, if it could be treated as my copy.
2004. 2004 volume.
My lords, 1 minute, I'm giving it. 2004 6 SEC 378. It's not there. My lords, I sincerely apologize for the inconvenience caused.
No, not at all, Mr. Naidu.
It was a miscommunication or misunderstanding on my part.
See,
I stand corrected.
This institution has a different culture altogether.
Yes.
So, and even in your absence, and I'm very happy about it, that even in your absence, not a single word was spoken on the merits
I'm
of
grateful
the
to
case
my learned friend. Nor can I
senior
expect
counsel,
anything other than fairness from
fearing
him.
for the opponent. So
Grateful.
this is how this institution
I do accept, my lords.
has thrived.
I only blame myself when it comes to the communication gap. Otherwise, I would have been here because all the way I came. My lords, perhaps whoever becomes a lawyer down the line, my lords, it's always the lure of Luca that takes everywhere. And the moment we got some chance, we logged into something else. With all our stall posturings, we can't help it. My lords, permit my lords, instead of holding up your lordships, I can pass it on.
Yes, you can.
Yes, another copy also.
Is it a copy?
Another copy also.
Yes. The ladyship may have that one too.
So can we retain the copy?
My lords, we could airdrop with all the terminology.
Not this.
In Supreme Court, my lords, we had the occasions of airdropping judgments to their lordships.
Is which paragraph you are relying?
17 minutes onwards.
This is about restoration.
Yes, my lords. In that case, my lords, dismissed for default. In our case,
that is different.
yes, my lords. In our case, it's nothing but kindly read that, my lords. Kindly read that.
Yes, yes.
It's been said, my lords, I believe that I am better off. I stand on a better footing. Because, my lords, when it comes to the matter that I've carried, it's a continuation of the proceedings, and the judgment alone has been set aside, and it's been restored. Once it's been restored, my lords, it gets restored with full vigor. Whereas a party's default, despite his default, once it's restored, he gets the benefit of an order. Here, there's no default on my part. There is an order, and my lords, one of the learned judges has differed with that one. But anyway, that becomes a three-judge bench decision.
Tomorrow you'll pass order on your.
So be it. Yes.
Lord, may I just answer my friend Lord's submission, if I may be permitted, subject to the learned ASG.
Yes. Mr. Ranjit Kumar, may I just point out two, three things subject to your.
Please, no. So that's why I said first you have a.
Very well. I'm grateful. Now, in this matter, kindly see on 19/12/2023, writ petition came to be dismissed. Kindly note the date.
Yes.
19/12/2023. Thereafter, on 29/2/24, contract was signed and the contract has been given, which makes the entire formality complete. 29/2/24.
Yes.
The SLP was filed. I'm not saying when it was listed. SLP was filed on 15/3/24 thereafter.
Yes.
And in SLP, there was no interim order operating. Fourth aspect. Then finally, kindly see the order passed by the Honorable Supreme Court, where categorically it has been brought to the notice of the Honorable Supreme Court. Please see the order passed in the SL.
Yes.
It's the order dated April 26th.
Yes.
Kindly go to para 7. During the course of hearing,
yes,
we have so and so heard so and so. Then the bid of the second respondent was found compliant, and contract has been awarded by the first respondent. It was categorically pointed out to the Honorable Supreme Court with regard to the subsequent development which has occurred in this matter. Then thereafter, court proceeds to pass the order on the short ground that it is not a well-reasoned order. And finally, in para 10, we accordingly allow the appeal and set aside the order dated. That's all. Then thereafter, again, they made after the matter was remanded by the Supreme Court, the matter was listed on 13/5/24 before the Honorable Court. Please take the order. Dated 13/5/24 on IA number 6554 of 23.
Your Lordships have the copy of the order of 13th May.
13th May. Where is that?
May. Yeah.
We have copies here.
Have copies here. Please give. 13th May, yes, it is there.
Yes, please. Para 2, so and so, learned counsel for the petitioner contended that since the development have taken place, categorically said so, after disposal of the writ petition during the pendency of the case before the apex court, the petitioner was to bring same by way of this amendment petition. On query made by this court, learned counsel for the petitioner contended that at the time of hearing of the case before the apex court, subsequent developments have not been brought to the notice of the apex court by the petitioner. However, so-and-so stated that opposite parties have brought to the notice of the apex court such fact which has been reflected in para 7 of the order to the effect that bit of the second respondent was found compliant and contract has been awarded by the first respondent, but the apex court has not passed any order on the same. In any case, since the petitioner has filed the application for amendment, the writ petition by bringing such developments on record and by serving copies thereof on the so-and-so, the prayer for amendment is allowed, consolidated so-and-so, IA is disposed of.
Millets, that's amendment application.
See, there is difference.
I'll answer in the end.
There is difference between the case which you are citing and the case which we are dealing with. In your case, an interim order was granted. And thereafter, your writ petition was dismissed on merits. The Supreme Court was of the view that reasons were not there.
Yes.
Therefore, the matter was remanded back to the court.
Yes.
So the difference is that on merits, the High Court was not satisfied on the merits of your case.
Yes.
So therefore, because of remand, the interim order cannot be restored. This is
may I answer that?
Yes, sir.
I just wanted to make one submission.
Yes, please let him so that I can have the reply.
Yes. My lord, it is well known in law, and I am not citing any judgment for that, that any interim order merges in the final order.
That is what I was.
Please, not your lordship. I'm just adding to that. And if there was a demand or setting aside of that final order, it will never automatically revive any interim order. Number one. Number two, my lord, as the learned ASG said, my lord, that since subsequent developments were brought to the notice of the Honorable Supreme Court, also that the contract has already been awarded. My lord, my friends, my lord, it is my instruction, my lord, I did not appear in the Supreme Court, that my friend did seek stay there. The Supreme Court did not grant any such stay.
It's not correct, Millets. Because I appeared.
Anyway, so I am
on the admission day itself, it was disposed of.
This information has not been registered in my mind.
No, that statement may not be right. That's all I submitted.
No, I am only just in.
So the very same day, it was in my favor.
I am saying that the interim order cannot automatically get revived.
Yes. We will pass an order on that.
Please.
Yes. Millets, there is a beautiful word, Millets, called lagomaki. That means fighting on words. That's what we lawyers do. Now, my lords may kindly see. What's been said is that once it was dismissed or allowed whichever way, according to the respondents, it merges, the principle of merger applies. That's why the question of automatic restoration doesn't arise. I take it. Then, my lords may kindly see para 10, which has been referred to your lordship's attention, of the Supreme Court's order. What's been said, we accordingly allow the appeal and set aside the judgment and order dated 19th December 2023 and restore writ petition, so and so. Now, Millets, what has happened? There was a restoration, and my lords may well appreciate when it comes to dismissal by whatever reason, be it for default, having become ex parte, or whatever, a dismissal applies with all its full force. And Millets, what could have been quite established, according to the respondents, took a reference in the Supreme Court saying that there is a judicial cleavage on that point. It needs to be referred to a larger bench. That's how it has come before what is Jacobs, 3-judge bench. They're also there, they have split hairs, and then they have said that it could be otherwise, whatever. Ultimate analysis that, Millets, once it's been restored, what's been said is that, Millets, if there is an express vacating of that one before disposing of the matter, then they have to reapply. Otherwise, they need not reapply. That's what that's been said, Millets. In my humble submission, be it a dismissal for default or be it a dismissal on merits, once it's been restored, Millets, restoration of status quo ante, which includes all positions put together. The merger has now got aside and demerger applied in the sense the order still existed. This is my submission, Millets. And Millets, by next adjournment, will be getting along with our submissions.
We will pass orders on
as my lords, please.
Interim application tomorrow. And then
we only say that, Millets, if my lords were to consider status quo as on today, or else an order, as my lords indicate. previous IM alert that's been showed by the respondents is only with regard to amendment that's been allowed. It's in a different context.
Yes, may I add just one sentence in the matter, with the permission? Now now they are seeking to put the clock ante. Putting the clock ante would be having serious impact on the public interest and the public revenue. That's one of the aspects, especially in the tender matters. Kindly bear that in mind.
Well, it's with great respect. It's the Honorable Supreme Court that put the clock back, not me.
No.
We leave it to your lordships. Anyway, ultimately the ball is in your lordship's court.
I'm just tracing the stay application which they have filed, my lord. They say it is therefore prayed this honorable court may be pleased to direct stay of the letter of acceptance along with the stay of operation of the project agreement. Both had happened already, executed in favor, and further stay any other action pursuant to the electronic tender, which also is over, floated, and or he may be pleased to direct stay of commencement of work. Now, commencement has also happened.
That's a tall claim, my lords, with great respect. 300 days window.
Status quo would mean, my lord, that if my lord, in my humble submission, judgment of Justice A.P. Sen way back in 1983 in BC Bharat coking coal matter.
I
believe, Millets,
That you'll continue working.
Millets, I believe
I can guess that this interlocutory application has been vetted by Mr. Rao.
I'm only saying, my lord, if status quo, my lord, if the order of status quo is passed, my lord, apart from what the learned ASG said against public interest, it would also, my lord, affect everything else which is on ground. Because excavation of a mine is, my lord, a cumbersome and a wholesome project.
They're prepared to lose thousands of crores in the name of public interest. Keeping aside.
This is what sister is observing, that if we grant status quo, then they will continue with the work.
I leave it to Millets. Ultimately, I can pass on the judgment of 1983 of Justice A.P. Sen
so be it. Let
in
it be
Bharat coking coal matter, where he says status quo, how it is to be interpreted.
We do submit, Millets, whatever we are required to, Millets. Ultimately, your lordships would take a call on it. We just have
if there
it.
is any judgment, you can give that.
Yes, I can take it out. I will take it out and give it to the court.
Please.
Well, I beg to appeal the NCC matter.
Petition also, my lord, I don't remember of it. It is 1983 and it is Bharat coking coal and Justice A.P. Sen speaking for the bench. It's a short order, but the question arose of contempt in a status quo.
It's been said, Millets, when it comes to status quo, that leads to a lot of litigation. It ought to be specific. A blanket order of status quo is always deprecated by your lordships.
Lord, regarding the next date, my lord,
I believe, Millets.
Next week, my lord, there is a problem for me, and my lord, thereafter there is a holiday. So if it is convenient to your lordships, my lord, 28th and 29th October, which is working here, my lord, and our courts are
my lords have seen. Out of thin air, they've produced figures of 60 crores spending on that one, 30 crores, Millets. By that time, it will be 200
When do you
crores.
want? When do you want?
Next week, Millets.
That suits us. Well, we can have it next week.
You can join
Next
online.
Wednesday, Millets.
I have a problem, my lord.
At least we'll complete, Millets.
With all due respect and humility, I say, my lord, because I'm have to
Well, if you
travel.
can commence the matter next week.
online?
No, I have to travel, my lord.
All right,
Other-
you come on
other-
28th.
I'm
28th.
going overseas.
Or, no, 29th. 20th, you must be busy. All of you.
No, 28th Supreme Court is closed.
Oh, 20th. Oh, all right,
Supreme
then.
Court is closed for that week, whole week.
Then you can come on
The Deepavali
26th.
holiday.
Millets.
Then you can come on 26th and argue on 28th.
Millets.
Deepavali holidays last week.
Tomorrow.
Millets, it's more than a month's time. My position would be devastating by then.
No, we will take care of everything. See, no one can be left remediless. So if the finally we
Then,
reach
Millets,
a conclusion,
let this adjournment, with great respect, without causing offense, Millets, let this adjournment be at their request.
all right, all right,
My friend.
all right.
Sorry, my lord.
No, I can't be blamed
It's all right.
tomorrow that I did that and drag the
I
matter.
say that. I will. But somehow, my lord, it seems unfair.
Oh,
my friend to say
please,
that.
let's stop using such spell
No,
words. We
because
are tired
I
of
was
this.
fair to you in the beginning
We are
and
tired.
now
We are tired
you
of this
being unfair.
unfairness business,
You are
Millets.
being unfair to me.
Yes, we are tired of this unfairness
Yeah, that's all right.
phraseology.
That's all right.
And everybody knows who is unfair, who is
We
fair.
will have a chance to get.
I have only said that you want a month's time. Let it be.
I didn't ask for a month's
Please,
time. Today we are on.
please. Senior counsel appearing on behalf of the parties, and Mr. K.M. Nataraj, learned Additional Solicitor General, representing the Mahanadi Coal Limited.
Mahanadi Coal.
Please.
Mahanadi Coalfield Limited. Stop. List this matter tomorrow.
Both the
List
cases.
these matters tomorrow for orders on prayer for interim stay. Stop. Next. And senior counsel appearing on behalf of the respondent.
Sorry, opposite party number.
You are for?
I am for the petitioner.
Mr. Naidu.
Because I beg to appear for NCC petitioner.
Mr. Naidu and senior counsel appearing on behalf of the petitioners has submitted that this matter may be taken up on next Wednesday, on 9th. On 9th.
Next Wednesday, my lord, is that's what my friend wants.
3rd.
24th. My friend.
September.
Oh, sorry, October.
On 3rd of October.
3rd of October.
Full stop. Mr. Ranjit Kumar and senior counsel has submitted that he has some difficulty on the.
It's entirely personal, my lord.
On the said date.
Personal difficulty.
Personal difficulty on the said date. Full stop. Next, because of the intervening Puja holidays, let these matters be listed on, cases be listed on 28. The cases shall be listed on 28/9 and 28/8/2024.
Lordship.
Great.
Within first five. Judgment citation I am giving, my lord. That is, Lord, 1987.
Within first 5 cases.
One second, Mr. Natar. 1 second, Mr. Natar. 1987 supplement SCC 394. And I will give copies, my lord. My friend will hand over copy.
Yes,
Sorry,
Mr.
Mr.
Natar.
Please.
Yes,
On the interpretation of status quo.
I'm not on this. On 28th, this is actually Diwali holidays. It starts. Could it be little earlier or little later? That entire week it's a Diwali holiday. Mr. Ranjit Kumar, have you taken note of it? Mr.
I know.
Naidu.
From 28th to
He is
3rd in Supreme Court.
Yes, 28th that entire week.
It's working.
No, that's right. But
He may be out of station.
No, I'm not
21st.
in the week of the 21st. I'm here. I can be
fine. That week would be fine. 23rd or 24th.
23rd, all right.
23rd?
Very well.
No problem. 23rd October is fine.
23rd.
But let's once again, I apologize for the inconvenience.
No, Mr.
Because I was mistaken in getting it across. Gratefulness.
Very grateful for the indulgence.
Will be listed tomorrow, my lord, again.
That for orders. That limited purpose. For
Yes.
passing.
Yes, we do understand.
Both. IAs are there in both. You're not insisting.
Yes, yes, both.
Last time your lordships observed that in the rejoinder or the rejoinder, they have stated that to stay operational.
No,
We will see. We will pass an order irrespective
will
of
cover- that will
application
cover
or
both.
whatever based on the submissions which have been advanced,
Yes.
and then we
That will
we
cover
shall
both
report
the
our
cases.
order.
So be it.
My lord, may not have that 23rd is the date where that your lordship will be sitting post lunch again. Arbitration matters.
So it will be taken up in the first half.
Very well.
Yes,
Please.
that's great.
Very obliged. Great.
Item number 21.
That's in that case, so that rejoinder which I am filing today, that may be taken up.
File it in the registry.
21, let it come up. That matter related to Narsu Pradhan, that matter regarding.
Pending.
Let it come after 4 weeks.
It's this matter after, these matters after 4 weeks on hold.
Item 23.
23. Ah, we said we'll see when it reaches. What that matter and everything. Huh?
Item 23.
I'm appearing for OP number 13. I'm appearing for OP number 13. Madam.
First hour he was asking for time. We said when the matter reaches, we will see. So let us see why he was asking for time. Outer has been filed. Prayer. Yes, to set aside the order in another. That is what I was.
Right, they had earlier filed a review that has also been dismissed.
Review has been filed saying what?
Same grounds as has been agitated in the writ application. That has also been dismissed.
Review is not there. This is item?
This is the first item, 3973.
373, हाँ, urgent होगा.
There is no representative as requested on behalf of the petitioner. List this matter on 1 week.
Item 24.
Petitioners who are the students of ITI colleges prefer to sanction the stipend for which they will continue their study in the ITI colleges. According to the government notification, they have been selected by the government and they have admitted.
Where is the government notification?
And that is, I am mentioning para 14 of the read petition that according to the.
Have you annexed?
No, my lord, I have not annexed, but that is the.
Difficult.
Well,
Unless you annex, how can we?
But that is my annex, my lord. That is para 14 of my read petition, my lord.
That is not annexure, that is quoting. Have you annexed that document?
My lord. Page 20, my lord.
Yes.
The students have been.
Page 20 is what? Where is the policy of the government?
Normal. That is the all the students have been selected by the government selection procedure.
So you remember the policy? Have you memorized the policy?
My lord, that is the after the colleges have fulfilled all the eligibility criteria, then the.
Mr. Counsel, where is the policy? You are entitled for a scholarship.
My lord.
You are entitled for a scholarship under a policy.
My lord.
Where is that policy?
Madam, come with that one, madam.
All right, which for the state? If they are entitled to a scholarship, then why should not they get?
In all these cases, Lordship, remember the some cases, Your Lordship, hearing that ITI matters, that they are followed there because of
Those are different things.
similar, these contingents arises in this case also, that as per our counter, after inspection, it was found that certain deficiencies are there. Because of the deficiency, the college does not fulfill to get the scholarships. According to the students.
See, if you take this stand, then you are defeating your own policy.
Yes, but that I on
Based
last
on your selection process, they were admitted in the institutions, these training centers, ITIs.
Yes, my lord. Because the students have no fault.
And after they go there, you declare those ITIs not
yes, ma'am.
up to a standard.
Yes, ma'am. That has happened.
So that has happened. Then
So you have to send them to
indirectly, you are defeating their right, and you are defeating your policy. And your policy is simply on papers.
Urgent for some time. I'll take instruction on that. If they're entitled to that as per our policy,
If
definitely
they're entitled to, you should. Why should they file a writ petition? And even if there is,
I'll verify if they're entitled as per our. Yes, ma'am.
and this should happen for everyone, whosoever has taken admission. Either you declare that you don't have ITIs. So, like just a situation where you have 40 engineering colleges in the state, and you allow students to take admission, and then you say that all the engineering colleges are deficient, and therefore the students will not get a scholarship. Then they're right. Everything is defeated. Let an exhaustive. You have filed a counter affidavit.
Yes, ma'am. I have filed counter affidavit.
Also, the judge also filed.
Principal. Now I'm filing the counter affidavit matter. This is the copy. That's all.
Last occasion, all Lordship directed.
An additional affidavit we filed on behalf of the state of Odisha, disclosing their policy in respect of grant of scholarship to such SC/ST candidates who are given admission in various ITIs, but subsequently those ITIs are subjected to action because of the deficiencies found later. What do you do? Found later? Found later. Stop. It is the case of the petitioners in the recent batch of writ applications that they were admitted in various, in one ITI or so many?
6 ITIs.
Huh?
6 ITIs.
Six in different ITIs based on a selection process conducted by the state government, conducted by an state agency, and the colleges were allotted to them by the state agency.
As per their
ITIs were training centers were ITIs were allotted.
These are private institutions.
All right, but you had asked them to go to that.
No, they, as per their merit, they have opted those colleges.
They had opted. It is not that.
Not that, because as per their merit, they have opted.
And forgot. Proceed to the- Discuss matter on. Is there any policy of the state government to shift such students in other ITIs which, what do you call, recognized or what?
Necessary infrastructure or what?
Different, our
They
inquiry
have
reports.
passed an order, you have passed an order that you shall not take admission. Or
Like
something
that case.
In other cases, your lordship is hearing those
In other
matters.
cases, so this is the order. So no suspension, no
Yes,
disaffiliation, no.
From the beginning, I'm saying that all those matters where your lordship is hearing those matters, that these are the deficiencies for which they have been restricted not to take admission.
See, both the issues should be taken separately.
Yes,
and should be addressed separately.
Yes, madam, because these students are prior to and they have got admission. The institutions, they have been restricted for future admissions.
Yes.
Future admission, but if they don't have the infrastructure, what lessons will they impart?
That your lordship has directed as an interim measure to, because that is the fault. After some days, we have restricted.
We are looking at the practical side
Yes,
of it.
madam, that
They may face difficulty. What students, what will they study?
here, madam, there is an inspection report. On the day of inspection, no student was also there.
So on paper only they take.
I'll take instruction, even if that college does not fulfill that criteria, whether the students will suffer or not, that instruction I can take.
So visa circle. Yes. Is there? Other ITIs having sufficient infrastructure or not. So stop. They will also have to address, the state will also have to address the question as to whether the purpose of grant of scholarship to SC students, SC, ST candidates to pursue their courses itself stands defeated because of the attending circumstances.
Right.
Yes. 2 weeks.
Next. Item number 25.
Today I received the counter mailer for opposite party number 2, 3 and 4 mile. Then counter has not been filed by opposite party number 5 and 6. In that case, notice has not been issued, my lord. And
Is there any compulsion for us to issue notice?
my lord, they have admitted everything, my lord.
Then no.
Your lordship kindly see the counter at paragraph 4, my lord. Counter paragraph 4. That in reply to the affirmation made in para 1 of the writ petition, it is humbly submitted that the unauthorized construction has been made by some local people at Netaji Chowk, Bulla.
So they will take a decision. Why should we issue notice?
Here we have filed a counter stating therein that admittedly there is not encroachment by other people. But the land belongs to Orissa Hydro Power Corporation, which is not independent body, and the revenue authority that the Tahsildar cannot evict them. Only because it's a municipal area. Now municipal corporation along with the OHPC can remove them. But admittedly, encroachment is there. And I've given the ROR. Your lordship, the entire all record of rights name stands in the name of Energy Department.
We impleted, not a party in the case.
Hydropower is OP number 4.
OP4.
Your Lordship, I may be pardoned, Your Lordship. We are for the intervener. I have filed the intervention application, Your Lordship. The petitioners who claims to be the public spirited person, they are seeking direction from this honorable court to demolish or removal from the unauthorized construction. That is the plot number against whom they have sought for. That is, we are the Netaji Subhash Bose Club that is situated on that plot number 3530. Without impleading us as a party, because we are necessary party against whom they have sought for the removal. So I have filed an intervention application. We may be impleaded as opposite party number 7, Your Lordship.
Now since you have appeared,
yes, Your Lordship.
We can hear you and we can issue notice.
Yes,
Everything will be.
Yes, Your
May I
Lordship.
say the dispute. The petitioner are S12 members of that club, my lords.
Yes, Your Lordship.
Now they have been removed from that club. Because they have been removed, now they have filed this writ application for.
Yes.
So let it be removed now.
Done by them earlier.
Yeah.
No, now they are saying that now
Yes,
other activities are going on.
That is
because they
unauthorized construction, buildings and shop rooms.
That was not there when you were there.
No. And that was specifically
No.
given.
He has stated in
Yes,
a positive
yes.
manner that plants were fixed, a park was done. That is all right.
That
But
is
you
in.
can't take over private property and build shop rooms and give it on rent.
No, Your Lordship. So far as this club is concerned, that is with the agreement with the Sambalpur municipality, Your Lordship.
They are saying we
I will
don't have-
supply every document, Your Lordship.
They are saying that land belongs to the power corporation.
Your Lordship, I will produce that agreement, Your Lordship, with the Sambalpur municipality. That is the Netaji Club.
You can have an agreement with Mr. Samantray also, but if he is not owner of the land, what is the use?
Yes, Your Lordship, but I may be impeded as party so far, so that I can file a counter, Your Lordship.
Who are you?
I am the Netaji Subhash Bose Club secretary, Your Lordship. That the property that belongs to 3530 plot number, Your Lordship.
No. Is it the case that you have encroached upon?
Yes.
Yes, Your Lordship. They have sought for the demolition of that club, Your Lordship, and I am the secretary of that club.
They have
are-
sought for demolition of unauthorized
Yes, Your Lordship.
construction.
Yes, Your Lordship. And that the plot, so far as the plot is concerned, and that Netaji Subhash Bose Club that is situated over there, that plot 3530 only.
Why should we enter into this? They shall look into it. The corporation.
Yes, Your Lordship, and it is pending before the collector, Your Lordship. So far as this unauthorized construction is concerned, Your Lordship, let that matter be adjudicated by the collector, Your Lordship.
The petitioner in the you were a member of the club.
No, I am not the member.
No,
Nobody-
were you earlier were
Earlier
you?
he
petitions.
was the member of the club.
Earlier
Secretary.
I was the
And due
at
to
that time, that plot was allotted for a garden mine.
Your Lordship, due to unauthorized antisocial
And that is
activities
an
of that
Annex 3,
person,
right?
the petitioners, and thereafter he has been removed from that secretary post, Your Lordship. And now he is challenging that it is the unauthorized construction and it should be demolished, Your Lordship.
Present writ application in the nature of public interest litigation has sought for a direction for encroachment
Remove it.
for removal of unauthorized encroachment from public place opposite place of opposite party number 5. Who is opposite party number 5?
Orissa Hydro Power Corporation, OHPC.
He has also given the letter, my
Is
lord.
belonging to Odisha Hydro
Power Corporation.
Power Corporation.
Limited.
Comma, which place? Limited. Which place?
Bargad.
Sambalpur.
Sambalpur. So next, a counter affidavit has been filed on behalf of opposite party number
1 to 3, no, 1,
party
2 and
number
3.
2 and 4.
2, no,
3
sir.
and 4.
2 to
2,
4.
3 and
2, 3 and 4. 2, 3 and 4, wherein the allegation of encroachment has not been denied. So next, Mr. Samantray and AGA has submitted that the land in question belongs to hydropower source. And any action for removal of encroachment, if any, can be taken by the municipal corporation.
Burla NSC Millers, OP number 6.
Line is
NSC, because it's Burla, under Sambalpur Hydropower Corporation.
Or any other competent authority, including the collector of the district, if so required. So stop. Next. An intervention application has been filed on behalf of Netaji Subhas Bose Club, Sambalpur. Learned counsel appearing on behalf of the intervener has submitted that the petitioner has alleged encroachment having been caused by him, by Netaji Club.
Yes, Your Lordship.
By Netaji so-and-so club.
Plot number 3530.
Without impleading the club as a party in the present writ application. So he has further argued that the collector of the district has already taken steps into the is already in session of the matter.
Yes, sir.
As regards the allegation of encroachment over the said plot. Unauthorized encroachment. So, next, considering the facts and circumstances of the case, we dispose of the writ application with an observation that it will be open for the opposite parties, including the HPCL, OHPCL and OHPCL, corporation, municipal corporation, and the collector of the district to take appropriate action in accordance with law for the removal of encroachment from public land if such allegation is found to be correct.
Oblige.
Applications.
DC Miller.
Yes.
Actually, this is an application regarding the appointment of arbitrator Miller.
Yes.
The respondents have appointed a person as an arbitrator who was working with them since last 34 years, to which the petitioner has raised an objection and thereby also sent a notice to them, to which they replied and continued the arbitration proceeding.
Where is the arbitration agreement?
Lordship, I have filed a belated stage, but that same probably has not been tagged into case record. Lordship, I will take this time to pursue the same matter.
Whether there is any arbitration agreement or not?
Yes, Madam. There is an arbitration agreement. I have also reflected the same.
This application cannot be maintained.
Yes, Lordship.
Application.
Arbitration agreement is there, Lordship, but the same has not been tagged into the case record, Lordship.
This cannot be entertained. You are required to. The present application has been filed.
Lordship, 2 days I will file the
appointment of arbitrator under section 11(6) of the Arbitration and Conciliation Act. Stop. It is stated by learned counsel for the petitioner that there is an arbitration agreement. Also, however, the arbitration agreement has not been brought on record, has not been annexed with the application seeking appointment of arbitrator. This application in this background cannot be maintained and is accordingly dismissed.
Lordship, with permission, Lordship.
Item number 2.
The petitioners are not required. File.
Lordship, I will file within 2 days. Kindly
file that. Yes.
Item 2.
Please, Lordship. Here the application is for appointment of arbitration.
arbitrator.
Where is the arbitration agreement?
The annexure 3, page 19. The arbitration clause is at page 22, my lord. 22.
Yes.
Point number 4, my lord.
Yes, issue notice.
Oblige.
Number 3.
I seek your lordship's indulgence for appointment of an arbitrator. My lords, the arbitration agreement is at page number 33 of the paper book.
Yes.
My lord,
Other formalities compliant.
yes, my lord, notice of arbitration was served. They have replied to the notice of arbitration, so the delivery is complete. And my application is complete in respect of the fact that I have appended the delivery notice also, my lords.
Issue notice.
I'll accept.
So and so accepts notice. Any suggestion?
My lords, yes. My lords, in this matter, their arbitration clause is unworkable in terms of the fact that their own office bearer has been made the arbitrator. And as my lords already knows, in Perkins Eastman and others.
No, but who has to be appointed according? Any name? What is the amount?
My lords, it's below 1 crore of unpaid dues and an issue regarding illegal termination.
Yes, will you seek instructions or?
Actually, my lords, if we may be permitted to leave it in your lords' hands as to who my lords may.
All right, we'll see. Let a copy of this application be made available to learned counsel. So and so. Stop this case next Wednesday.
Deep obliged, my lords.
Next Wednesday is 2nd.
2nd October, my lord.
Then 9th October.
9th.
9th.
Item number 4.
My lord, this is also appointment of arbitrator, my lord. The clause for arbitration is at page 21, my lord.
Yes.
The point number 4.
Yes. Who is for the other side?
No, my lord, this is a praise matter.
Issue notice.
Item number 5.
The 5 is same also.
Yes.
This is also a praise matter, my lord.
Issue notice.
Oblige.
Item number 6.
I am appearing through virtual mode, Your Lordship. The proprietor of that illegal firm died in the meantime, Your Lordship, so I need to substitute him. It's a need.
Where is the agreement?
Agreement is a annexure 1, clause 27, Your Lordship. Page 12, Your Lordship. The opposite party has already appealed. They filed their counter.
This is a proprietorship concern.
Where is the agreement?
Page 12, Your Lordships.
Which clause?
Clause 27, Your Lordship.
Yes. Yes.
No, it's perhaps seeking substitution, my lords, because this is a proprietorship concern and the proprietor has died.
Oh. As requested on behalf of requested by Mr. Amitabh Pradhan, this matter on 2 weeks so as to enable him to take steps for substitution in the wake of death of the petitioner during the pendency of this application.
The representative, Your Lordships, of the legal firm.
All right, you do whatever you want.
Lordship, obliged.
Item number 7.
Obliged.
I humbly pray, Miller, for appointment of arbitrator under section 11 of the Arbitration Constitution Act 1996.
Yes, where is the agreement?
Agreement is found place, already notice was issued, but the opposite party has not yet appeared. So,
where is the arbitration
agreement is found at page 48 of my lord's brief, whereby arbitration clause is stipulated. At page 48.
And who is the other side?
Other side, Odisha Livelihood Mission under the authority of the Odisha Mission Shakti Department under the government of Odisha.
Well, it's Mr. Ishwar Manthi, Additional Standing Counsel, was specifically assigned this matter. Now, he has resigned already. Therefore, if your lordship may kindly grant me 2 weeks' time, I'll take instruction.
Despite service of notice, there is no representation on behalf of the opposite party. Stop. You are AG or
Additional Standing Counsel.
ASC, State of Odisha, seeks adjournment to seek instructions in this regard. Seek instruction to obtain information as to who shall represent national. What is that mission?
Odisha Livelihoods Mission.
Odisha Livelihood Mission, which is under the Department of
Odisha Mission Shakti Department under the government of Odisha.
Under Odisha
Mission Shakti Department.
Mission Shakti Department, Government of Odisha. 2 weeks. Yes, on 9th.
Item number 8.
Item number 8, Your Lordships. Last time, as we were actually venturing that some settlement hasn't arrived, it's a small amount. If my young friend agrees, I propose the name of a young advocate called Subhankar Raut, if he agrees.
So I was suggesting the name of Mr. Tarun Patnaik, my lord, but if my learned senior.
Tarun Patnaik.
You're okay with that also?
Tarun Patnaik. Yes.
Item 9.
My lord, I have already entered my appearance for the respondents, my lord. My lord, if my learned senior gives me a copy, my lord, I'll file my reply within 2 weeks, my lord.
What is? Are you objecting to?
My lord, actually, I have not got a copy, my lord.
All right. Let a copy of the arbitration of this application be served upon Mr. Mohanty, Front Counsel, appearing on behalf of the opposite party in course of the day. Discuss matter on 9 so as to enable him to seek instructions and file seek instructions.
My lord, may 9th have some difficulty, my lord. Any other date, as your lordship please.
Yes.
Is to fix it after vacation.
Then 23rd.
Grateful, man. Deeply grateful. Obliging.
Item number 10.
Madam, item number 10, there is a CPW matter, and this claim in respect to Division 3, but we'll examine that it is amalgamated to Division 1. So let's keep it to next week, then I will take the instruction to
9th.
As requested by Mr. A.Q. Patil and Deputy Solicitor General, list this matter on next week. This matter is pending since 2020.
Yes, my lord. I am concerned. Twice I took time, my lord. Yes.
Please ignore that. Next time it is not adjourned.
Once I have taken time, my lord.
All right.
9th.
We'll see.
Item 11.
Well, not listed till 10 October 2023. Thereafter, twice it was listed.
All right.
Item 11.
Lordship, in this matter, I am appearing for OP number 1. This application is not maintainable. In view of, basically the present petitioner has excluded the jurisdiction of this honorable court by virtue of clause 21 of the present, that's at page 21, your lordship, of the section 11 application. Lordship has page 21.
Yes, sir.
The clause reads, clause 21, governing law and jurisdiction. Wherever judicial intervention is possible, the courts at Hosur, Tamil Nadu, shall have jurisdiction in respect of all matters relating thereto, and each of the parties hereby consents to the exclusive jurisdiction of such courts.
Yes.
I am for the petitioner also, and I already got the counter copy. I want to file my rejoinder.
No, but it is clear. There is no requirement of any rejoinder.
Yes.
This is your application.
Yes, sir.
No. And in fact, there is a decision by.
Yes, Your Lordship.
So in the light
So
of
one
this,
is the decision of Swastik Gases versus Union of Indian Oil Corporation Limited, wherein it states that the contract specifies the jurisdiction of courts at a particular place.
No, in one of the cases recently I have decided.
Lordship, it's the same judgment that holds good, and it's been referred in those judgments also. And there's another judgment of Indus Mobile Distribution Private Limited versus Datavine Innovations.
Yes.
The law is quite clear on that.
This application has been filed for appointment of an arbitrator under section 11(6) of the Arbitration and Conciliation Act. The arbitration clause of the agreement reads thus 21. An objection has been raised on behalf of the opposite parties over maintainability of the present application, relying upon clause 21. Agreement. Where is the agreement?
Lordship, that's at page 21 of their section 11 application. Clause 21.
Clause 22. Clause 22.5.
Lordship, there's a governing law and jurisdiction. That's clause 21.
22.5.
Yes.
Learned counsel appearing on behalf of the opposite parties has relied on clause
21, clause
1.1 of the said agreement, and has raised preliminary objection over maintainability of the present application. First off, he has submitted that the parties had agreed, under clause 21 of the said agreement, that the courts at Hosur, Tamil Nadu shall have jurisdiction in respect of all matters relating to the said agreement. So, in such view of the matter, he contends that this court may not entertain the present application. Stop. He has placed reliance on the Supreme Court's decisions in case of decision. Could you get my decision? Okay. So, after having perused the terms of agreement as quoted above, I find substance in the submission advanced on behalf of the opposite party. First of this application is accordingly and the decisions rendered by the Supreme Court in case of so-and-so and this court in case of so-and-so, I find substance in the submission made on behalf of the opposite party. Stop this application is accordingly dismissed as not maintainable for want of territorial jurisdiction. Stop.
There is a clause, my lord, clause 22.5, which says arbitrage tribunal is there. But upon lordship kindly see that page, last paragraph.
20?
page 21, that 22.5, any dispute of whatsoever nature as contemplated in clause 22.1 above and or difference which could not be settled by the parties through negotiations after the period of 30 days from the service of the notice of dispute shall be finally settled by arbitration in accordance with the Arbitration and Conciliation Act 1996 and or the amendments modification thereof. The arbitral panel shall be empowered to adjudicate and resolve the dispute.
So that is not the question, Mr. Counsel. The question is of jurisdiction.
Jurisdiction is there. You'll also kindly see next page C. The venue of the arbitration shall be in Hosur, Tamil Nadu, or at such other places as it is convenient to the arbitral panel.
That is what has been held in that decision. What is the meaning of place of arbitration and the venue of arbitration? Those aspects have been dealt with in those decisions.
May I pray online more, my lord? The parties at liberty to approach the learning.
The parties are, it goes without saying that the parties are at liberty to approach appropriate forum for addressal of forum for appointment of arbitrator.
Item 12.
I'm appealing to the other side. I
Wait,
think
it's
3 weeks time to file objection.
I have no objection. As requested on behalf of the opposite parties, list this matter on 3 weeks so as to enable and counsel to file objection to the present application for appointment of arbitrator. Yes.
Item 13.
Well, let's give a date only.
Yes, you will get the date.
The agreement is annexed 1, my lord. The agreement is annexed 1 at page 6. And
So who is for the other side?
I am for opposite party. Allow me for its time for filing company.
File 4 weeks.
Item 14.
May I please, madam? This is an application for appointment of arbitrator. Notice
Who is
was
for the
issued-
other side?
Other side, madam, learned friend is here.
I'm for the opposite party. I have filed my objection. My objection is on 3 counts only. One, there is parties are not
Only.
added regarding arbitration
3
clause.
counts only.
My lord?
3 counts only. Your objection is on 3 counts only.
Basically, there is regarding arbitration clause and the contemplated arbitration that has been section on
Arbitration?
section
Just a
21
minute.
notice.
Arbitration. First is arbitration.
Arbitration clause, the parties are not added in because in view of the contention that has been raised in section contemplated section 21 application, that is only for rendition of accounts. But all the parties are family members. It is partnership business, and the notice the dispute, the contemplated notice dispute is only as regards rendition of accounts. And clause 21 is for arbitration, and 22 says the partnership shall be guided and governed by the Indian Partnership Act 1932. So the dispute squarely covers is for rendition of accounts only. So these are the 2 objections only in this ground.
But that is also a dispute.
That is a dispute, madam.
That is a dispute, and that dispute requires to be resolved. The question is, the dispute can be resolved through what?
So in section 20, they have not made out a dispute in any case. Otherwise, if there is a dispute that can be referred, they have not made out a dispute at all in section 21 notice. And the reply is interestingly, the reply is also given, that is at para, they have annexed my reply also.
No, forget reply. Let us see the arbitration agreement.
My lord.
May I place it, my lord?
Yes.
Your lordship would see the arbitration agreement, find space at annexure 1 at page 16, clause 21.
Just a page?
Page 16, annexure 1, clause 21.
Yes, it's clear, Mr.
Your Lordship would see even in my, it will be covered regarding accounts also.
So, suggest a name.
But they had suggested a name in section 21 also. Our reply, we had not denied, but we have no objection even if he is appointed as the arbitrator also.
Who?
Here they have suggested say, Amarendra Mohanty advocate of Bhubaneswar.
His name is there.
So his name won't be there, my lord. I don't think so. Not in the panel. He's a senior member of Bhubaneswar Bar, my lord.
The dispute is of Bhubaneswar.
Bhubaneswar, both the parties.
Can you suggest some name from this list?
As you Lord Millet, I would suggest the name of Mr. Shanturi Sarangi.
Have you seen?
Just
see and then.
Yes, sir. Shanturu Sarangi, if my learned friend is senior advocate Shanturu Sarangi.
No, whether his name is there or not.
His name would be there, ma'am. I'll just check.
$43.
Yes, madam.
43.
Shanturu. Grateful, madam.
Item 15.
Item number 15, today I am appearing for the petitioner. Today morning I have filed Vakalatnama on consent from the petitioner.
You are appearing for the petitioner.
Yes, on today morning the file has been transferred to me.
What is this?
For appointment of arbitrator under section 11.
Yes, who is for the other side?
I am for the OP number 2.
I am for the appointment number 1.
So all of you are fighting.
Next week.
No, where is the agreement?
Agreement page 15, annexure 1.
Any opposition?
My lord,
the lordship kindly peruse the page 15, clause
The
15.
clause 50.
They have not considered the arbitration clause. They have not suggested any arbitrator.
We have already issued notice to the OP number 1 for appointment of arbitrator.
This matter was taken up on the last week. I remember.
Advocate has changed, my lord.
So this arbitration agreement is contrary to the provisions of the Arbitration Act.
Yes,
I will examine that. Therefore, I am
Counsel appearing
praying
on behalf
for
of the petitioner seeks adjournment to address this court on the point of law in the background of the nature of arbitration agreement under clause 15. Arbitration clause under clause 15 of the arbitration clause of the agreement. So, as requested, this matter on. After all this, yes.
Item 16.
Lordship.
Item 16, my lord. Prior to filing of this 11(6) application, I had approached this honorable court by filing a writ petition. And in the writ petition, they filed a counter to the effect that this is not adjudicated, cannot be adjudicated under 226 of the Constitution. And they filed a counter to the effect that
that is immaterial. Let us see your agreement.
Yes, sir. Please kindly come to page 21. Page 21, the arbitration clause is there. para 43. 42 I exhausted, 43 settlement of dispute. In the event of any dispute difference between the parties arising under the connection with the agreement or any associated agreement entered in pursuant to the agreement, they shall use the reasonable endeavors to resolve the matter on amicable basis. If one party serves formal written notice to the other that a dispute difference of such description arisen and the parties are unable to resolve the dispute within a period of 30 days from the service of notice, then the dispute shall be referred to an arbitrator for arbitration of the dispute to be appointed by the parties with their mutual consent.
Yeah.
My lord, please see.
Here I have filed my objection. In paragraph 3, I have stated that there is no signed arbitration agreement between the parties. Then
This agreement is not signed.
No, this is not signed.
My lord, if your lordship kindly see the next
allow
page.
me? The next objection is that the notice which has been sought upon me for appointment of arbitrator, that is a defective one. Now, he has referred to 3 tender call notices. He has not specified what are the disputes and in respect of the which tender call notice. And there is a mechanism provided in this clause 43 that has also not been followed.
That I'll explain. My lord, if your lordship
Just a minute. So, like, let me see the notice.
Is at page 37, annexure 5.
Arbitration consultation.
Page 37. Let me see the table. Table at page 37. Now, reference has been made to 3 tender call notices. Then, my lord, next page. Well, it has not been mentioned what are the disputes and respect of which tender call notice. And under the clause which has referred to clause 43, it mandates that the dispute has to be specified.
You are representing whom?
And the opposite party.
Who is the opposite party?
Odisha.
Initially, it was IDCO,
Industrial. Taken over by Odisha Mining Corporation.
Odisha Mining Corporation. And you had filed a writ petition that.
No, I had not. I filed the writ petition.
Sorry, counter affidavit that because of the arbitration clause, you should file an arbitration application.
Yes.
And now you are saying that arbitration application.
No, I have said that signed agreement is not there.
No.
Sir.
In the alternative also, I have stated that even if it is treated as an agreement, if mechanism has been provided in clause 43 itself.
Forget, we are not required to go into such things. We have just to appoint an arbitrator. Tell me, and your stand which you are taking may be very expensive for you. Just suggest a name.
Lordship, may appoint from the panel.
No, tell us.
I have suggested Justice.
You have suggested, he may agree, may not agree. Mr. Since he has suggested, you are opponent, we can agree on either of the names. This is Viswajit Mohanty?
Yes.
Viswajit Mohanty? All right.
Item number 17.
On Monday, my lords, I've e-filed the objection affidavit. I'm handing over a copy to my learned senior.
Are you raising any objection?
Yes, my lord. There is no arbitration clause in this case.
Correct. Let us see. Where is that agreement? Arbitration clause.
Section 7, I'm invoking section 7(4)(c). If your lordship will take up page 179.
Page 179. Which is this case? RBP 34.
My lord. It arises out of the construction of a canal.
All right.
179.
79. Yes. Where is the arbitration clause?
Arbitration clause, I have given a notice, my lord, wherein I have requested for arbitration and they have not denied. That is at annexure 12, page 212. 11/9/2023, 212.
So you have made this application under which provision?
My lord, if your lordship will see section 7(4)(c).
Yes.
Where arbitration agreement has been defined, that what will constitute an arbitration agreement. If your lordship will take up 7(4)(c), an arbitration agreement is in writing if it is contained in C, an exchange of statement of claims and defense in which the existence of the agreement is alleged by one party and not denied by the other. So, my lords, this 11/9/2023 letter has specifically said that your imposition of penalty of 63 lakhs is bad and I dispute it. And thereafter I say
No, Mr. That is not the provision. It says that if you allege in one of your communications that there is an arbitration agreement.
This is what I've stated. Kindly see page 213. 212, my lords. Let me read the letter.
Yes.
Pursuant to our letter dated 22/11/22, you have released security deposits of such and such and additional personal security and closed the contract with imposition of penalty of rupees such and such by the aforesaid letter. We have specifically stated in our letter dated that why the aforesaid imposition is illegal and bad in law and therefore no reason has been assigned for levy of such penalty. Next page, we have been denied the imposition of penalty as aforesaid. A dispute has arisen between us with respect of illegality.
That is not. Where did you mention in your communication?
Later on coming.
Yes.
And permissibility of imposition of penalty in terms of the contract and the Contract Act. Such a dispute needs to be decided by arbitral tribunal with the consent of parties. Hence, we propose to adjudicate the aforesaid dispute through an arbitral tribunal, taking into account the alternate dispute resolution scheme prevailing in India.
Please, Mr. I have seen the entire content. These are the circumstances,
my lords,
where the court can presume or that there is an arbitration clause,
my lords,
including D.
My lords.
D says
my lords.
that, sorry, C says that if there is some exchange of
statement of claim,
communication, and it is not that you allege or you demand, you assert that there is an arbitration agreement, which they don't deny. Then in that case, it may be presumed that there was an arbitration agreement.
There is an arbitration agreement. But what my submission is, there are three types of arbitration agreement.
There is an agreement. There was an arbitration agreement.
No, I'm coming to that. Why I'm saying this? Because there are three types of arbitration agreements. One is regarding a future dispute, where the court is always finding whether there is an arbitration agreement or not. Relates to a dispute to be raised in future. The arbitration agreement contained in the agreement relates to a dispute in future. Second is relating a present. Suppose there is an arbitration agreement, there is no dispute. There is a dispute and we agree to adjudicate by arbitration.
Absolutely right.
And third is that already there is a dispute and past dispute I'll refer for arbitration tribunal for arbitration. So, my lords,
Everything, Mr.
so that is the concept of section 7.
Concept of section 7 is one aspect. The existence of arbitration agreement is essential for invoking power under section 11.
That
All
is
right.
what I'm trying to persuade your lordship.
You have
that
not been
section
able.
4C, section 4C. So what they have done actually, state government has done, all the agreements, they have deleted arbitration.
They can do.
No, they can do. But this is a futuristic litigation resolution. Now they cannot by retrograde step take a plea that no, there will be no arbitration. You go to commercial court.
You can challenge that policy in some other
See,
proceeding.
I'm not challenging because
No, you can challenge that policy in
correct.
some other proceeding, but not here. When we have to, I have to find out whether I have the jurisdiction to appoint or not. So it's a question of the limitation imposed on the.
That I understand that because the essentiality is about the arbitration agreement. So if I am not able to convince your lordship that I may be permitted to withdraw it and file it before the commercial court, Bhubaneswar.
And counsel appearing on behalf of the petitioner after some argument seeks permission to withdraw this application under section 11(6) of the Arbitration and Conciliation Act with a arbitration and conciliation. He submits that he shall be approaching appropriate forum for a resolution of the dispute. Stop. That goes without saying. Stop.
There is one
Liberty C. Again, this court has very limited scope while considering an application. So whether to appoint an arbitrator, not to an appoint. No question of liberty. That liberty.
Why I'm saying this? Because in the Commercial Courts Act, there is a pre-litigation mediation that has to be done. So again, I have to go for wait for another 3-4 months.
Mediation is a very very good this thing that gives you that mediation process gives the parties space.
Yes, space to resolve the dispute.
No, to think to what extent they can sustain their claims. So that is a very important stage that should be utilized.
What I have experienced,
I have experience.
Twice it goes.
Mr. Counsel, I have experience of mediation. I am a tenth mediator, and therefore I can tell you that even in cases when the mediations fail, the parties at least come out with something in their mind that to what extent they could sustain their claims, and for future that is very beneficial. So failure of mediation is immaterial. The process of mediation is very important.
That is correct.
Item number 18.
18-year lordship, sir. I'm appearing for the Paradip Port Trust that discussed lordship may appoint Justice BK Naik.
We have discussed.
Yes. On column. Okay. Supplementary.
Item 19.
19 minutes. I have the objection. The affidavit is ready. If your lordship permits, I can hand it over or e-file it.
The objection in my is lordship permit, but the objection towards appointment after notice, they replied that which I annexed your lordship. That the objection towards appointment, when I invoked the arbitration clause requesting appointment, they made a reply which also annexed that your lordship.
All right, let that come.
Yes, I am handing over a copy to my learned senior.
An objection has been filed. Or you are going to file or you have filed?
We will, in course of the day, we'll file it.
an objection to the present application for appointment of arbitrator is proposed to be filed in course of the day. Stop. Let the same be done. So a copy of the said objection has been served upon learned counsel for the petitioner. So stop. This matter on 2 weeks.
Next sitting, your lordship.
Next week is holiday.
9th Feb. Do you think?
Yes, your lordship. Sorry. 2 तारीख is holiday.
Item number 20.
Yes.
20, if your lordship may grant me time till 9th October for filing objections. Last chance. Sir.
By way of last indulgence. Week's time is allowed for the opposite parties to file their objection to the present application for appointment of arbitrator. Yes. This matter on.
My lordship, Madam, the matter has been transferred to me.
File your wakalatnama in registry.
Special list. Item number 1, CRLMA 166 of 2024.
May I please? Your my lord, the
Yes. Restored. This one for default.
my lord, dismiss for default.
Then
My lord, on 3/5/2024.
the criminal revision number 7/2000 came to be dismissed for default by an order dated so and so on account of non-appearance of learned counsel for the petitioner. First of this application has been filed for the restoration of the said criminal criminal division number 7/2000. For the reasons disclosed in the present application, the same is allowed. First of let criminal division so and so be restored to its original file. What is the offense?
My lord, there is 5 convict, my lord. The offense, my lord, charge, my lord, 304B, 498 and 201. I am the brother-in-law. In the meantime, my lord, 3 of the convict died. Only left the brother-in-law with the present petitioner and another, my lord, with the husband. Now both are jail custody, my lord. Both are jail custody, my lord. I am filing. Now the present petitioner, my lord, arrested and in jail, my lord. Here, my lord, I have read the entire evidence, my lord. At best, a case of 201, my lord.
Who is in jail?
Both are, my lord. In view of the dismissal of the
Brother-in-law and
the husband of the deceased, my lord.
Brother-in-law and husband of the deceased.
My lord, I am for the brother-in-law, my lord. I am not moving the application for husband, my lord.
And husband is in jail since when?
My lord, the both are arrested, my lord, on 18.
So this criminal division is on behalf of one person or?
Only one person, my lord.
And what about the husband?
Husband, my lord, not moving, my lord.
He has not filed criminal division?
Not filed.
Let the criminal division be filed. Right? And he is in custody since when?
Since 10/8/2024, both are arrested, my lord.
And before that?
My lord. And both are, this petitioner is now 80 years.
And what is the
conviction? Entire evidence, my lord, no one stated against me that I am demanded or subjected to cruelty or ill treatment soon before her death, my lord. The deceased committed suicide, my lord. But admittedly, 201 is there, my lord. I am fairly concerned, my lord, after going through the entire evidence, my lord. 201 against the present petitioner as because he and the husband, my lord, both are taken the deceased to burial field, my lord. That is the evidence, my lord, there, but nothing there so far as 304B.
What is the sentence?
Sentence 7 years, my lord. And out of 7 years, this petitioner pre-trial stage, my lord, 2 months, and now, my lord, 1 month, 7 days. If PO Act is there, my lord, is applicable. Is applicable. I have, my lord, read. PO Act is applicable, my lord, to this petitioner. At best, a case of 30201, my lord. PO Act is applicable. If also.
Once the conviction is not altered to 201, then the question of
No, even if it is 7 years. PO Act is, even if it is 7 years, PO Act is there, my lord. I have gone through, my lord. You lordship 360. PO Act, you lordship kindly see 360 of the IPC, my lord.
360 of the IPC?
My lord. Sorry. My lord, CRPC.
CRPC. So 360 says you have Prohibition of Offenders Act.
My lord,
Therefore, 360 will not apply.
Here, my lord, if you lordship 360 and the PO Act, my lord, it is applicable.
Therefore, the 360 will not apply,
my lord,
because you have the act.
My lord, that is, my lord, it will read together, my lord.
To 360, you can refer to the
my lord, it is read together, my lord. That's why I am saying. PO Act section 4, my lord. I have got the book.
Mr. Samantra, 360 will not apply because you have a special
act, special act, but it may read together, my lord, for convenient, my lord. This is the PO Act.
All right, we will take up this matter on when do I take up? 9th. All right. Is this matter list revision number so and so 9th? Make a mention. Please make a mention. Please make a mention, even if it is not likely to be taken up on 9th. Please just let me know. I'll take up.
Okay.
Item number 2.
Item number 234.
Yes, that NDPS.
Yes, my lord.
Yes.
Here, my lord, item number, first item number 2. 2 is the, my lord, is the wife of accused number in serial number 3. Is the, my lord, namely, my lord, Luki Banerjee. My lord, Luki Banerjee, she is the wife of Barun Banerjee, who is the serial number 4, my lord. Serial number 3. And one Ramsakhi Devi is serial number 4. She is no way connected with this. She is from another place. She is no way connected with this accused.
Who is for the estate?
Pardon?
So whether case diary is there with you?
No, so in fact, last occasion my friend undertook to satisfy lordship so far as rigors of section 37.
No, but his submission is that beyond the fact that there is confessional statement, there is absolutely no material against her. So if during the course of investigation some further material has come, then we can examine. If there is absolutely no material, then it will not be proper for me to reject it.
In that case, I will examine whether
you just call for the, what is the practice here? We call for the records. This thing.
Case diary is another thing. We obtain minutes. We obtain.
This matter on 9th. In the meanwhile, so as to enable an AGA to obtain a carbon copy of the case diary. There is no question of carbon copy anymore. What is the practice here? They prepare carbon copy or
No,
computer?
they, because in the police station, they prepare about 6 to 7 copies, so they send us 1 copy of that.
They use carbon or
Yeah,
what?
yeah, mostly
Carbon is
carbon
still
copies.
in use.
Nowadays,
Nowadays, it is all printed.
Xerox,
Printing is very risky.
Yes, Millers. True.
Because the investigation is a confidential
True,
business.
true, Millers. Earlier in the other older system, each CD was numbered consecutively, so they couldn't tamper with it. Now, Millers, it is easy to tamper.
The original copy is to be produced to before the magistrate, concerned magistrate, and carbon copy is to be sent to the court as and when required.
See,
That
the
is
the case diaries under the law are required to be written every day.
Yes.
Once the investigation is taken up, the investigating officer has a duty to record it every day. Even if nothing is done, he has to say nothing could be done.
Yes.
But that is the mandate of law, if I have not forgotten under the CRP.
That is the mandate of law.
See.
Item.
Next. Ninth.
Yes, item 2, 3, and 4. Item number 5.
From the order sheet, it transpires that this criminal division application was taken up on several dates for final hearing. On most of the occasions, there had been no representation on behalf of the petitioner. When the matter was last taken up on 23/2/2024, a request was made on behalf of the petitioner to adjourn the case to seek instructions as regards present whereabouts of the petitioner. Thereafter, on 2 dates, the matter was taken up when adjournments were sought. Today, there is no representation on behalf of the petitioner. This application is accordingly dismissed for default. Yes. Bill for joy. Yes.
Item number 6.
So will be liberty to file an application for restoration. Yes.
Item 6.
Lordship, pardon me, in item 5, Your Lordship, in the
No further, madam. Sorry. You don't have any idea whether the person is there or not.
Lordship, we haven't been able to. Your Lordship, for do we have tried our best to.
So therefore,
Lordship, we give one last chance.
it's very embarrassing. You can file a restoration application. But council today in council, Mrs. MS so and so states that she has no instructions.
I believe there is a judgment of the apex court which says that criminal revisions cannot be dismissed for default.
See, criminal appeal cannot be dismissed for default. Show me whether such decision is in respect of criminal revision also.
I think, Lord, there is a 2013, I believe there is a judgment.
Sure.
If your Lordship will adjourn it, I'll give you.
All right. Because criminal appeal is a matter of
Yes,
right.
I understand, my Lord.
And therefore,
the same reasoning their Lordship say that since this is a revision where a point of law is to be answered, so it cannot be dismissed for default, but the court has to answer the point of law.
no, see, answer the point. There is difference between two. Criminal appeal for the reason that the appellate court has a duty to see all the records afresh, reappraise the evidence and reach its own conclusion. In criminal revision, the party may accept the final order of the appellate court.
Question is when your Lordship admits the revision.
If the party does not intend to press the revision application, then the court is not bound to decide that. That is not the case with criminal appeal. Criminal appeal, even if it does not press.
That's true.
So that is the difference.
Yes, your Lordship may see, I believe, 2007 7 SCC 623, Madan Lal Kapoor versus Rajiv Thapar. It was held that a criminal appeal must not be dismissed for default and held that this rule would also apply to criminal revisions. Uh-huh. 2007 7 SCC 623. 2023 data recent.
We'll see next week.
There's another judgment, my lords, 2023 live law SC 689, CRPC 73, 385 and 386. Criminal revision petition needs to be considered on merits, even in the absence of party or counsel.
I'll follow. Next week, madam.
Lordship, after 2 weeks, if that is. After 2 weeks,
All
if
right.
that is. Obliged, Lordship.
Just give the.
I'll give that.
Yes.
Item number 6.
There is no representation on behalf of the petitioner. Press this matter on 9th.
Item number 7.
Yes. Matter.
Item number 8.
There is no information regarding the petitioner, my lord. In the meantime, I have also already left that chamber, my lord. Lord Justice S.K. Sahu.
9th. It will come on 9th because we have been pointed out that decision of Supreme Court. So we need to follow.
Item number 9.
Yes, Samanda.
Item number 10.
Yes, my lord. In this case, I am appearing for the opposite party number 2 informant. In the earlier occasion, honorable courts also grant two date to appellant petitioner, my lords.
All right, we'll have to. Let me see. Nine. I'll do something on 9.
I am appearing for petition lordship. We have filed a fresh book lordship. It's a transfer brief lordship. And some time lordship.
9th?
Yes, Lord.
But this is a case of 2001, my lord.
What kind of? Let us see.
Both courts.
Let us see, Mr. Counsel.
Item 11.
Okay.
Sorted, ma'am, fix up.
9th.
9. Item 11.
Yes, we cannot hear you, Mr. Mahapatra. You are not audible, Mr. Mahapatra. Which item?
11.
Yes, Mr. We cannot hear you. Next.
Item 12.
This, can it come some other day? I'll verify whether the petitioner is.
In fact, this is what I am planning to do. I request the
To obtain the status of the present petition.
in all the cases.
Yes.
In all the cases, up to say 2005. Up to 2005, just give us the information.
Yeah.
So we will provide you the list.
Yes.
The names of the parties,
Yeah.
and then the DGPs are ensure that.
Now we can get from the concerned SPs from
All
the
right.
respective districts. Also
So we will supply you that. This is what, in fact, most of the cases.
Will abet that we understand.
Many of the, see, these are old criminal division
Right.
matters pending. And see, today what happened, you must have seen that that I dismissed a criminal division for default. He was on bail. He was taken into custody. 80 years old person. So he has been taken into custody. He must not be knowing that criminal division is pending,
Right.
something is there against. So these are see conflicting circumstances which need to be balanced. And then pendency of criminal revisions unnecessarily, that is also all right. 9th as requested.
Note 13.
This matter, my lord, was pleased to grant me time last Wednesday. I have sent a registered letter in both the appellants. There are two brothers, scheduled caste people, my lord, to Baleswar. I am at any moment I am expecting the reply. I have not got.
All right, as requested.
Next week.
No, those.
No, that's.
Item note 14.
Lord, item 14, your lordship had a query last time from me whether 324 is attracted or not. Now in the present case, my lord, only the accused has been charged with two offences, 448 and 324. Whereas regarding 448, since it is an official premises, it's a waiver society, and the present petitioner is also a member of this society. So 448 is not attracted. And regarding 324, my lord, also 324 is not attracted in my view, because reading the FIR, starting from the FIR itself, it shows the very simple nature of fact is that the present petitioner went to the society to purchase some bundles of thread for weaving purpose. Now he purchased some 10 bundles of threads, and when he came back to his house, he found that it is 9 bundles. He returned thereafter to the society and asked the secretary, the informant, it is 9 bundles. So the provocation was sudden between the parties, and out of that he assaulted the informant with a table lamp. So 324 my lords, I am placing, if your lordship permit me, 320.
May say one thing. So far at the time of pronouncing the sentence, the London magistrate had dealt with this POA. He rejected his prayer for releasing one POA on the ground that considering the gravity of the offense. But if it's 324, now he is aged of 70 years. That lordship can
Lordship may pass appropriate order for acquitting him because at best 334 can be attracted out of sudden provocation where maximum punishment is 1 month, my lord. But whereas in present
there will be conviction.
Conviction is after, but 324 is not attracted.
He is assailing that and he is saying is taking it of general exception of certain provocation. All right, I'll allow.
Maybe acquitted, my lord. Your lordship may pass.
Allowed.
And it's not also a weapon of offense as described under section 324. The weapon of offense, it is not included.
Don't make that submission. Weapon of offense, everything is weapon. So one can be killed by a pen.
Yeah.
Yes. Allowed.
Item 15.
Lord, item 15, my lord, I have sent a letter today. I have sent a letter today for we don't know the present status of the petitioners.
All right, 9th.
Bless you.
Item 16.
9th, no one appears.
Item 17.
Item 15, my lord, there is noting that there is no LCR, my lord.
All right, let it come on 9th also.
Pleasure.
Item number 17.
LCR may not be required. We don't know. These matters are pending for 2000. Yes.
Item number 17.
Yes. Yes.
Item number 18.
Please, ma'am. This is a conviction under section 307.
So, may pay one thing. So, unfortunately, my office could not get the records of that case. So, 9th, I will request my learned senior to.
I have nothing. It is not legible and not readable also.
All right, 9th.
9th, so that.
Lords, one thing can we do? If the TCR is here, can we take copies by pen drive?
Yes. Yes.
But that is also being allowed in other courts.
Yes.
That you can do.
The whole problem is they are so old briefs, the papers have started disintegrating.
No, then we can make this system that if you apply for, in fact, I was intending to do this, that there shall be a counter where whosoever goes and requiring a copy of any pleading in which he is a party, then that can be supplied to
yes.
on requisition
That would be very
in a
good.
pen drive.
Yes.
So that can be easily done. So I'll see to it that the system is there for from next Monday.
But I found in other courts are not.
No requirement of any judicial order or any court.
Courts are
Let
granting
there be a system.
Yes.
That if anyone goes and says that
Yes,
this
yes,
is my wakalatnama or anything that I appear in this case, I want to have for that can be supplied.
Yes.
In a
that
pen
would
drive.
be very well done.
Item 19.
Yes. 19 all appears.
Item number 20.
In item 20, we will look out for the whereabouts of the petitioner. Lordship, item 19 was not good.
Are you attached to any office dealing with criminal cases?
Yes, Your Lordship, I'm attached to senior
Then you
advocate.
should derive the advantage out of this situation. The old criminal revision applications are pending.
Yes, Your Lordship. I was.
I can assure you that I'll give you liberty to address the court.
Sir,
So
Lordship,
please
I was-
prepare yourself, even if this is how we have learned. So, all right, 9th, as requested on behalf.
Lordship, item 19 on the rooster wasn't called.
9th.
19, 1-9.
Is also 9.
1-9. Your Lordship, I was to appear on item 19 as well.
19, yes.
Yes, Your Lordship.
19 and 20.
Obliged, Lordship.